18th, 2022. Tonight we have a joint meeting with the ZBA. What I'll do is I'll read some notes and then welcome Chairman Rand to call his meeting to order as well. This open meeting of the Planning Board is being conducted remotely, consistent with Governor Baker's executive order of June 16th, 2021, an act relative to extending certain COVID-19 measures adopted during the state of emergency. All members of the Planning Board are allowed and encouraged to participate remotely. The order allows the Planning Board to meet entirely remotely so long as reasonable public access is afforded so that the public can follow along with the deliberations of the meeting. The public is encouraged to follow along using the posted agenda unless the chair notes otherwise. Members of the public who wish to view the live stream of this meeting may do so by going to the Northbrook Remote Meetings on YouTube via the link listed on the agenda. Ensuring public access does not ensure public participation unless such participation is required by law. This meeting may feature public comment. I'd like to now confirm that board members anticipated on the agenda are remotely present and can be heard by stating the following. Planning board members, when I call your name, please respond in the affirmative. Amy Pretsky?
Here.
Anthony Zaitin?
Here.
Michelle Gillespie?
Here.
And Millie Milton.
Here.
Staff, when I call your name, please respond in the affirmative. Robert Federico.
Here.
Great. And I don't see Fred.
He should be on his way.
Okay. Just to cover ground rules for the meeting, I think this applies to the entire meeting for this evening. For presenters or applicants listed on the agenda, the chair will invite each speaker or applicant on the agenda by name to make a presentation and speak to their application. Participants will provide their full name and hold until their name is called. Each speaker will be asked to mute their phone or computer when not speaking and to speak clearly in a way that helps generate accurate meeting minutes. Those responding will be asked to wait until the floor is yielded to them by the chair. Speakers who wish to respond to the comments of others do so through the chair, taking care to identify themselves. Each vote taken by the board or committee will be conducted by roll call vote. For items of public comment, after members have spoken, the chair will forward public comment as follows. By phone, dial *9 to raise your hand and wait to be recognized by the chair. Please note part of your phone number will be visible to those viewing the meeting. By Zoom, click raise hand on the bottom of your screen and wait to be recognized by the chair. The chair will ask members of the public who wish to speak to identify their names and addresses only. Once the chair has a list of all public commentators, the chair will call on each by name and afford 3 minutes for comment. At this time, I would like to invite Chairman Rand to call the ZBA meeting to order and read any announcements he needs to read.
Okay, my name is Richard Rand. I'm the chairman of the Northbrook Zoning Board of Appeals, and it's the opening of the January 18th, 2022 meeting. And this is an open meeting of the Northbrook Zoning Board of Appeals, and it's being conducted remotely, consistent with Governor Baker's executive order of June 16th, 2021, and an act relative to extending certain COVID-19 measures adopted during the state of emergency. All members of the Zoning Board of Appeals are allowed and encouraged to participate remotely. The order allows the Northbrook Zoning Board of Appeals to meet entirely remotely so long as reasonable public access is afforded so that the public can follow along with the deliberations of the meeting. The public is encouraged to follow along the posted agenda unless the chair notes otherwise. Members of the public who wish to view the live stream of this meeting may do so by going to the Northbrook Remote Meetings on YouTube via the link listed on the agenda. Ensuring public access does not ensure public participation unless such participation is required by law. This meeting will not include public comment that I know of. Okay, let's like to call forward Fran Backstrom. Would you just announce whether or not you're here?
Present.
Mark Rattan.
Present.
Paul Tagliaferri.
Present.
Jeff Leland.
Present.
Okay, and Susie Stolica. She's not present. She's going to be late. Okay, go ahead, Carrie.
Okay, great. So welcome. Tonight on our agenda, we have a joint meeting with the ZBA. As we've met the last couple of years, I think the intent is to review some of the bylaws or all of the bylaws that the planning board has been discussing and considering to take to town meeting this year for town vote. What we're hoping to accomplish in the next hour or so is really to just get feedback from the ZBA. If it would be helpful to give an overview, we can give an overview of the bylaw. I think everybody has copies of them as well. If each board member who brought it forward could give an overview and then maybe a summary of the intent of the bylaw and then any additional relevant information. Would that be helpful for your board, Chairman Rand?
Yes, it would be.
Okay, does that, I think that would, and if there's other discussion, we can certainly do that as well. But why don't we get started unless there are any other thoughts or questions on that? Okay, Amy, if you wouldn't mind, why don't we start with brewery? I know you have information prepared there. So it'd be helpful just to go through the brewery
Sure.
bylaw, any pertinent information that we need to cover, and then intent. And then after this period where we get feedback from the ZBA, the planning board can continue to discuss. So we don't need to go round and round to resolve each one, but at least like present everything that's relevant, get feedback, and then we can continue discussion. So don't feel pressure to close every piece of it.
Okay, so for brewery, I have a small presentation. It'll be really short. That this has been on the agenda for a couple of years, so I figured I'd put a little slideshow together. Let me see. I'm gonna share my screen. Okay. Okay. Can everybody see it?
Yep.
Okay. Oops, it already changed pages. All right, so for brewery, I just wanted to do a quick presentation to answer questions that have been asked previously when discussing breweries. Questions such as licensing, definitions, what other towns have done. I'm bringing it forward because there are a lot of towns in the local area that have breweries, so I wanted to add it to our bylaws. First, I'll start off with licensing, and that really won't affect the planning board or the ZBA, but we do get questions on it. So for a brewery to be licensed, you need federal, state, and local licenses. All breweries have to start at the federal level. When they get to the state level, there are 3 different types of licenses. The most basic is I just have to move our picture so I can see. The most basic is the manufacturer of wine and malt beverages license. The second one, the farmer's brewery license, is what the local brewers get that I've talked to. I talked to Hudson, I talked to Westboro, I talked to Hopkinton and Grafton and Shrewsbury. So local breweries get this license usually. It promotes the use of local ingredients by requiring the brewery to grow or buy a percentage of the ingredients in Massachusetts. A farmer brewer may not sell any beverages at retail that were not produced by the brewer. Holders of this brewery license may also apply for a pouring license. If they apply for a pouring license, that's when they need a local liquor license. The third type of license is a pub brewery license, which is very similar to the farmer brewer, except for they do not have to buy the ingredients local. So the difference is the pub brewer can sell its beverages at wholesale and retail, but it's not allowed to self-distribute to retailers, as the farmers brewers are authorized to do. They also need a local liquor license if they decide to pour on site. These are just some definitions that I have found in all the other local towns. And if you actually Google Wikipedia, these definitions come up. A craft brewery or microbrewery is a brewery that produces small amounts of beer and is often independently owned. Many breweries also serve small selections of food items. The standard definitions, the microbrewery is defined as under 15,000 barrels. A nano brewery is under 6,000 barrels. And a brew pub is more similar to a restaurant. They brew their own beer, but only 25% of that beer can be sold off the premise. And they usually are like a restaurant and have food. The towns I researched, I found 3 different ways that towns implement a brewery into their town bylaws. They can do it under an agricultural use, which is what Hopkinton did. They can do it by defining breweries and adding to their use table. And they can also classify it as retail, restaurant, and manufacturing, but only if you have a district that allows all 3 of those I recommend the second choice in Northbrook because we don't allow manufacturing on Main Street. And we don't allow restaurants in industrial. That's how Grafton, Shrewsbury, and Westboro did it. Although when I was thinking about it, I actually think a brewery could go over by Wegmans because it's industrial underlying and there's a commercial overlay district. So off the top of my head, I actually think they could right now be sited over there by Wegmans. So I just want to give a couple examples. This is Startline Brewery in Hopkinton. They started as a farm with an accessory of food. Then they added brewery as an accessory. And then they started to grow their own hops. And now it's turned into just a brewery. They're not a farm anymore that sells tomatoes or anything else. The planner mentioned there that there's never been a complaint. And I was just thinking, if any of our farms are interested in doing a brewery, they could probably go this route. Because they grow their own hops, they're considered a farm. And the brewery part is their accessory. The second kind of brewery, which I think Northborough should do, is the type that adds definitions into the brewery, into the use table. This is Cold Harbor. They're in Westboro. They're a small brewery, but they're actually expanding. And they're moving into their, they're going to move into their highway business district and become more of a brew pub. But they're moving because they need more parking. And that's the one thing the Westboro planner mentioned, is that if you allow a brewery in industrial, make sure you have enough parking, like it's a restaurant, because they're very popular. What I find with breweries, it's not just all beer. They run a lot of activities, like Cold Harbor was doing yoga, Medusa does yoga. Medusa was actually in Hudson. That's the third way that I find that towns allow breweries. In Hudson, their breweries are on Main Street, where they have retail, restaurant, and light manufacturing. So they didn't have to add a definition to their bylaw. She just allowed them on Main Street because she allows all those uses. She said, even though they've grown, there's never been a complaint. They recently expanded an outdoor beer garden. And this year they're actually building a new brewery with a new type of beer and a gourmet restaurant. So, I mean, that's pretty much it. There's others. This one has sledding. And another question I was asked is concerns about expansion. This brewery in Hudson started as a small tap room in their downtown, but as soon as they grew and had to expand, they moved into an industrial part of town and they built a bigger brewery. So I think in Northborough, if there was something small downtown, just like Westboro with Cold Harbor, and they needed to expand, then they would have to move, just like other businesses do. This is my favorite, in Stowe, Vermont. And all the breweries, just to give people an idea who haven't ever been to a brewery, they have a lot of outdoor dining, which was great during COVID. Many grow their own hops and their own herbs, and a lot of them have even like amazing food. It's just not a brewery where people stand around and drink. So the observations I had of breweries are hours are limited. Very few go beyond 9 o'clock. Many are only open Thursday through Sunday. Some serve food on site. They allow food trucks, or they just bring food in. They're usually board games, trivia, singing. There's outdoor seating with tables and heaters, but mostly the towns that I all spoke to mentioned they've never had a complaint. They said, don't overthink it. The only issue that Westboro found was parking. So what I wanted to propose for Northborough is to use the same standard definitions that Westboro and Grafton and Shrewsbury are all using, which is a brew pub, which is mostly food, but they also brew their own beer or ciders, and only 25% of the production capacity can be sold off-site. And my idea was to allow those in the same districts as restaurants because they're pretty similar to a restaurant. Same with the Nano Brewery, which is only 6,000 barrels or less. I would consider those the same places, districts as restaurants. Microbrewery is a little bigger, so I wasn't thinking that maybe not downtown because there aren't that many big parcels left. And the brewery, distillery or winery is the larger one, and I considered only industrial. So that's about it. I don't know if anyone has any questions.
Chairman Rand, did you want to facilitate feedback from the ZBA?
I'll take any comments that people have.
Okay, it's Fran. I have my little yellow hand raised.
Fran, go ahead.
So, I mean, like Amy, I have frequented many of these and I do think it's a good idea. I'm very much in favor of the zoning if similar to restaurants that include alcoholic beverages. That makes perfect sense because it is similar. I do think they serve food because it's required by state law that they have to. It's somehow they get away from pouring licenses, but I think that that's important. I do have a question though as to why in the industrial area, do we have to have like special variances for restaurants with alcoholic beverages up by Wegmans because it's commercial overlay, that can be an N, where now we're saying by special permit. And I don't need that necessarily the answer today, but it's just a question to make sure that it is consistent.
You mean how I put the special permit in industrial?
Yeah.
I just added it by special permit because it is new. I didn't know if Fred or Bob or any of the staff would have any concerns. I mean, we could allow it by right, but
It's not allowed at all. I mean, restaurants with alcohol are not allowed at all industrial. And isn't that where Wegmans is, or does the commercial overlay negate that? And again, that's a question. I don't need an answer now, but it is a question that I would raise.
right. Yep. I was gonna ask Bob about the commercial overlay because I was just thinking about today and it came to mind that industrial with commercial overlay is Wegmans, but I don't know. Well, margaritas and Anzio Pizza allow alcohol. So they must allow alcohol up there. But even, I think the commercial district overlay, Kathy said, went further down the street. Like there's a dentist office and maybe there are some parcels left that could be developed.
Possible. And then just one follow-up question through the chair, because growing is an important thing. If it came to where they wanted to have off-site brewing and then have a smaller area, is there some way that can happen? And again, I don't need to know it. I just need to know that it's thought through.
Well, that's what Holden did. So they have a small, I don't have a picture of it. They have a small tap room downtown, and then you see the picture at the top is where they do the brewing, and they have a tap room there. So they actually have 2 liquor licenses. I don't know if they need to, if it's the same owner, but they do have both. They owned I've never been there, but they have a smaller tap room with food downtown, and then they opened up a bigger one in the industrial area where they also have food and tap room.
Thank you.
So, and yeah, and I think Medusa too, their tap room downtown isn't attached to their beer garden. So, and it seems like they just buy other parcels and just keep going.
As I recall, the Northbrook Crossing had 4 restaurants planned for it as part of the overlay district. So there's probably room there for a couple more.
And someone told me too offline that due to the census that Northborough might be getting a couple more liquor licenses, but I'm not sure if that's true.
Excuse me, to the chairs so that we can have a productive meeting. You have your zoning enforcement officer that's raised his hand for several minutes, is trying to answer all the questions. So we might let him speak since he's the most knowledgeable on this.
It's through the chair. I don't know if I'm the most knowledgeable, but in terms of the shops up at Shops Way, that is a giant use variance up there, and it had certain conditions and allowances placed on it. In addition to that, it was also falls under the the commercial overlay district, and that also has some allowances that are allowed. What I'm gonna have to do is go back and, basically do a hypothetical zoning interpretation, if you will. Can a brew factory or a brew pub or something like that go into that area? And if it does need some sort of a special permit, who's the special permit granting authority for that? So I don't have the answer tonight, but I can look that up and try to get you an answer within a few days.
Thank you. Yeah, I think, but it was just an idea I thought of off the top of my head, like Hudson, that maybe it was allowed, but by doing these definitions, we're also picking different districts to allow breweries or nano breweries or brew pubs.
The entire section where the Wegmans Plaza is entirely in the industrial district. But then again, when the use variance was granted, and they also stacked on top of it the commercial overlay district. So, where it's located in town is irrelevant. It's industrial with a couple overlays on top. So it's going to take a little bit of deep digging into the actual decisions that were sent out back at the inception of Shops Way to come up with some sort of a direction, if you will.
Okay, the planning board will have more time to discuss, so I'll just ask any additional feedback, in the interest of time, any additional feedback?
Well, go ahead.
Yeah, Mr. Chair, just a quick question, just for Carrie, for Amy probably. What is the purpose of this craft brewery? Does this impact any of the farm parts of town towards the north side of Northborough, like Tugas or Davidian?
Well, no one's ever come in, well, that I know of, no one's come in front of us to ask to do a brewery. Hopkinton did. Their farm did become a brewery under agriculture. I guess that would be another thing that would have to go through Bob and decide what they're trying to do and if it's allowed. I guess it would depend. Like Hopkinton allowed it because they started just growing their own hops, and so he considered the brewery agriculture. I don't know what would happen in Northborough. I guess it depends on how big they're going to be and what they want to do. Is that right, Bob? I mean,
there was a case, and it's somewhere in this area. Was it Neshoba Winery that had to go to the state because they were in jeopardy of losing their pouring license because they thought they were agricultural and the state didn't have the channel to provide for that. The last minute they said it was okay, where you have a farm that's raising their product on site, and they also wanted to be able to have their winery on site without having to get in trouble with the state or some sort of zoning law. It's something that is kind of fresh in my mind because they were in danger of losing their right to pour. So that's, if we investigate that case, it might give you a little bit of an eye-opening because it would be a similar situation. If somebody was to start growing grapes and then they started to start their own wine, a couple of 100 cases a year, and then it got bigger, next thing you know, they're like a Seconic winery down in Rhode Island. Who knows how big it can get. But I think that case with the state might be a little good information to see how a farm would want to kind of, navigate through the weeds to get what they want to do.
Okay, any other zoning board members?
Yes, if
Go
I
ahead,
might.
Mark. Yes.
Yeah, I wonder if we're just dividing this too finely between a nano brewery and a microbrewery, if we just wanted to condense those two together, because granted, you'd have a microbrewery in the downtown business, but I don't see anything the size of microbrewery having a lot to even exist there, so that I don't think they would go there. And And I don't know if this causes confusion saying, gee, am I a nano brewery or a microbrewery? How big am I? Am I going to grow? Stuff like that. I just not sure I know the difference too well between the two.
Yes, and it's interesting because Shrewsbury actually included microbreweries and nanobreweries downtown. I didn't include the microbrewery downtown because it's bigger, but they put both in town. And I was thinking the same thing. If you were gonna allow the microbrewery, why would you even put the nanobrewery? But it seems like all towns that do the definitions list all of them for some reason, but we don't have to. I mean, we can.
Well, I guess, does the state or federal differentiate between a nano brewery and a microbrewery, or is that merely a local definition?
I would guess it's local because some towns actually put the 15,000 barrels and the 6,000, and some don't even put 15,000 barrels. They just leave out the number. So
Okay,
I think it's just local.
all right.
Because Hudson just, I mean, when I talked to her a lot about it, and she's like, just don't overthink it. Just do it.
Okay.
So they don't have any numbers tied to theirs.
Any other comments, Jeff? Okay,
Okay.
Carrie, go ahead.
All right, great. Thank you. Amy, if you don't mind, stop sharing. I'm going to share. Next is we have two proposed bylaws that Kathy had submitted before she left. And I'm going to share those on my screen. Can everybody see here the two? Okay, so the first one here, and Bob or Fred, if you have additional information and want to jump in, feel free, appeared to just be a housekeeping item. Something that happened in changing the two-family dwelling unit bylaws that somehow was added in one section and just needs to be corrected. So if there's any comments for this one, I'll just put them both together at the same time so we can cover two in one shot. The second one is something that Attorney Pember came and presented. I think he's actually in the audience as well if we have specific questions about this. But it appeared that there was as Kathy describes here, and I don't need to read it word for everybody, but it was on a boundary to begin with. It was placed in one district. Attorney Pember came to the board on behalf of the owner of the property and had asked if we could rezone that. They evidently keep having to come back to the ZBA for variances whenever there are new tenants in the building, and they just felt it would be easier to zone this. The planning board requested letters from abutters to see if there was any opposal to this, and there were two letters in favor. There was one abutter that verbally told Attorney Pember that they were fine with it, but I don't think we ever ended up receiving it in writing. But any feedback on either article?
Zoning board? I don't have any.
Sharon, I'll just speak as,
Go ahead, Jeff.
more as a butter, because my family is one of the abutters on the second one. And we have absolutely no problem with that, and they're supportive of it.
Oh, that's right. Great. Okay, so straight from the source then. Thank you. Okay, I'm going to move right along here. Why don't we go to next on my list? I have signs. Anthony, you've submitted changes since I last sent I'm going to stop sharing. So I'm going to need you to pull up your screen.
I'll find it. Sorry.
Okay, that's okay. Amy, you also have enforcement. If you want to, do you want to pull that one up?
Yeah, either one, or I can pull up the signs too, or I can start with enforcement if you want to look for it, Anthony, or if you want me to pull up signs, I don't care.
Yeah,
either.
just you can if you have it there.
Okay. Should I start with signs or enforcement? Do you care? All right.
Whatever's on your at your fingertips.
Okay, the enforcement is actually right here, so I'll just bring it up. Okay, I brought this forward because through the past year, we did get a couple questions. There were residents that called in and they had questions like, does each violation count as a separate violation? Does each state count as a new violation? There were some questions about enforcement. So when I get questions, I start researching. So I go to all different towns. But the summary of what I did was, we currently have an enforcement section of our bylaw. There are 3 sections: general, enforcement requests, and penalties. What I wanted to do was update the enforcement penalty section to include enforcing conditions on special permits and variances, along with enforcing the bylaws. Because that's what I found in other towns, is not only does it say you have to enforce the bylaws, but you also enforce conditions that are on special permits. So I can start with that. Do you want me to read it? Do you want to read it? What I have up top is I just crossed out and I put the new one down because it was too hard. I was trying to fit it in between the other words and it was too confusing. So it just says that the building inspector shall be informed by written request or has reason to believe that any provision of these zoning bylaws or of any permit issued by the building inspector or the special permit granting authority or decree thereunder is being or likely to be violated, then the building inspector shall make or cause to be made an investigation of the facts, including an inspection of the property where the violation may exist. And if he finds any violation, then the building inspector shall give immediate notice in writing to the owner or his duly authorized agent and to the occupant of the premises, and shall order that any violation of the provision of the zoning bylaws shall immediately cease. And then if the building inspector determines there's no violation, he'll give written notice of its decisions within 14 days. So the bottom part we had, where it said the zoning enforcement officer, if he is informed by written request, if he goes out and finds that there's no violation, then he shall have action within 14 days. But what I added was to include special permits. And we talked about this as a planning board already. And when we talked about it, Mr. Federico can speak to it, but he mentioned this is what happens anyways right now. So it's not, I took it out of different bylaws because that's what they have written. But at that time, he had said this is what happens anyways. So it's not really a change, but it's just adding verbiage to make it more, oh, I see Bob raising his hand. Just so people understand it. Bob, if you want to speak, through the chair.
Sure. Go ahead, Bob.
Hi. What you're proposing is, it's completely redundant. You are adding verbiage, you are adding words, but the timeline in terms of 14 days is set by the state. Any provision of the zoning bylaws, when a special permit or variance is issued, those become part of the town bylaws, and those are in fact enforced as well. So, what you're writing, we've already done, both in terms of the schedule for 14 days, receiving it in writing. If there's no, if I'm not going to do any action on a violation notice, I've got to give the letter out stating why. But in terms of the zoning bylaws and any special conditions issued on a special permit or on a variance, those are covered as well. And in the bylaws from the town, those are explicitly called out to be maintained in perpetuity. We had a situation where the housing authority actually cut down some trees a couple of years ago. The neighbor complained, and in the original special permit that was granted to the housing authority, that a certain number of trees, a certain breed and a certain size had to be planted and maintained. Well, the housing authority cut them down because they get too big, they became a danger to the buildings. They wound up having to put in new evergreen shrubs. Okay, so we do, we do hold the property owner's feet to the fire because those conditions on a special permit or variance are in perpetuity.
Thanks. I just wanted to add it so when residents ask and they call in, it's just all there in black and white, makes it
Well,
easier.
here's the other thing.
Sure.
Last year, this section was gone over and approved by town meeting. And it was also vetted by town council to more accurately reflect what is accepted in the courts and by the other attorneys around the state. You know, I'm curious as to what the problem is specifically, that we have to add words that aren't gonna fix anything. Or just make it more interesting for somebody to read when they have a spare 20 minutes.
Okay, I'm just gonna go to the next part. For the penalty for violation, I added the conditions of the permit again, and each day that any violation is permitted to exist after written notification of the building enforcement officer shall constitute a separate offense. And I added the separate offense there too, because those are where we were getting the questions and
Well, Amy, with all due respect, you got the questions, but they never, ever were forwarded to me so that I could have an opportunity to answer them. What you're doing here is messing with something that the legal department set up last year and approved, and the town approved at town meeting. You know, the fact that, you know, you want to rewrite a lot of this stuff, it's redundant, and it could lead to, could open up other issues where, you know, problems are going to arise. So this is already on its way to town council to be looked at, because
Yep.
there are so many issues in here that are overstated or, you know, could be construed to be incorrect. This is a dangerous thing to do.
Okay, so that's duly noted. I think any bylaw will go to Attorney Dineski to review. Amy still has the right to bring up a bylaw for review. So we're just talking through it. And then if it turns out that it's not legal or valid, that's fine. It's good to collect feedback. So Bob,
That's
you,
all it is.
yep.
okay. And then if any feedback is also, if the ZBA has any feedback as well, we can package it all up and then, of course, work with Attorney Dineski, or maybe the planning board discusses after and decides otherwise. So just in the spirit of collecting feedback, is there any, Amy, is there anything else you want to describe through here?
No, just the final section D that I added, and it says the building inspector may revoke any permit issued if the violation continues. And that was in, I don't know how that would be illegal to add. It was in anything I've added is in surrounding towns.
It's
No.
it's in chapter 1 of our town zoning code.
Okay, so that's good feedback. Any additional feedback, Chairman Rand, that you want to call for from ZBA members?
I'd just like to say, I think it's overly broad. I think the original definition is fine. It's adequate. It's very succinct. But this one is any provision of the zoning bylaws. I mean, that could encompass anything on the zoning bylaws. It opens it up way beyond the special permit and a variance process. It opens up to all kinds of violations. And this is supposed to be pertinent to variances and special permits. So I think it's overly broad, and I think it's way too much. Any other members of the zoning board?
Mr. Chair,
Fran?
it's Fran. I don't want to spend a lot of time on it because it does have to go through council. And if we did just revamp it last year, maybe it's not something we should be doing this year. But if we do move forward, I would question the adding of after a written request to the building inspector, or if he has reason to believe there is a zoning, that there's an issue. And that puts, I think, a building inspector in a difficult position, because somebody might say something or he gets a feeling. It's always been, it has to be in writing. You have to put your name on it if you have a question or inquiry. I think that's a safer place to be from an accountability standpoint. So if this does move forward, I would strongly recommend that not be included. That was all.
Any other members of the zoning board? Mark?
Yeah, I guess I also have a worry about the word immediate in that section there, where I don't know what the liability would be on the building inspector if he doesn't do it immediately. I don't know what the legal ramifications of that would be. And then as far as section, I also have the problem that, yeah, any small infraction gets the whole permit thrown out in the last section. That then might lead someone to insist that, oh, he has violated his permit, therefore I want you, building inspector, to toss his permit, and if you don't, we will sue. Again, I don't know what the liability is for the building inspector to not do exactly what is said here.
If I may, through the chair.
Go ahead, Bob.
Thank you. The last thing any zoning enforcement officer wants to do is going this route on enforcements, okay? A lot of the times, the person who is committing the zoning offense, okay, sometimes doesn't know about it. And it's number one, our job is to educate the people in terms of what they're doing wrong and why they're doing it wrong, and where in the code it says what they're doing wrong. And we always offer them the opportunity to correct their situation before it gets to this point. If it's something minor like taking down a sign or something like that, we can get it done within a day or two. If it's something that's a illegal use, it could take a couple of weeks or whatever. And I try to work out a timeline with the offender to allow them time to fix the problem after we have a little education process to let them know what's going on. The first thing I'd want to do is definitely not write tickets or send people to court. By that token, if we don't do that, if we don't write some letters saying you did something wrong, we give you the opportunity to fix the problem. We also give you the opportunity to appeal to the ZBA to overturn my determination, which is fine. One of the things we've discovered by recently going through court is if we don't follow these steps one at a time and do it diligently and document everything, if it does go to violation and it goes beyond that to a court situation, the judge is going to want to know if we followed all of the things. Did we give the homeowner or the property owner opportunity to fix it? Did he have the opportunity to appeal? Did he fix it in a certain amount of allowed or agreed to time? Did we write the tickets? Yes, we did. And everything has to be done according to what would be pleasurable for the court to see. Okay, we have to exhaust all our other local measures before we get to this point. And I'm saying that's generally what we do. We've had cases where things get fixed in a phone call. We've had cases where things go on for a year and we've had to go to court 3 times to get some enforcement done. Okay, so it runs the gamut in Northborough. But again, the first thing to do, educate, give them the opportunity to fix their problems, and then we move on to an enforcement. Thank you.
Okay, great. Any other feedback? I want to make sure that we cover everything in the interest of time. Good to roll? Okay.
I just want to say something really fast, that I do thank Bob for describing that. And when I did bring this forward, it had nothing to do with any business or anybody in particular. I was just trying to give Bob the, what he might need to go forward if he needed it, because I noticed it in all the other towns. So if there were an issue or concern, I was trying to give the town the teeth that they needed, while also adding in a description on each violation of the zoning bylaws shall constitute a separate offense, because we did get questions on that. And I think when they asked, Kathy wasn't sure, but maybe Bob wasn't at that meeting. So I'm not, this really had nothing to do with any person or any business. It was just because we were getting all the questions, I started looking into it.
Yeah. And that's fine. I guess my point is that in terms of everything I need to do what I need to do on this area of my job here, I got last year. To be honest with you, it's I appreciate the time and the effort, but from my standpoint, it doesn't help me do my job.
Okay, great.
Okay, thanks,
Did you
Bob.
want to take any other comments, Chairman Rand, from your board? Looks like Susie may have one as well.
Susie,
Hi, everyone. Sorry I was late. One of my questions was for Amy. I don't know if I missed it. And then one was for Bob. So I'll just ask them both and then maybe they could take them. I wanted to know, Amy, if you had mentioned other towns had this or something similar as well. So that was my question, if neighboring towns and other towns in Massachusetts had something similar to this. And then my question for Bob was just on the time period when you're doing that educating of the property owner. How long do they have to rectify it? And is it on a case-by-case basis? Thank you.
Thanks. I'll answer
Thanks,
first
Susie.
if you don't mind, Carrie. I did find it in different towns, and a lot of them are very similar, but worded, they're all worded a little differently, but follow the same setup with the ABCD, the penalty, and then the pulling the permit, all the order. So I took it from different town.
You all set, Amy?
Yeah, thanks.
Okay. All right. Susie, as I said before, when I get a complaint or when I see an issue, I take a look at the issue and see what it is, see what the infraction it is. And, I approached the property owner, a person responsible, to let them know what's going on and give them the opportunity to fix it. I mean, sometimes, like I said, it's as simple as, you've got a company, like, I'll say it, FedEx was putting signs all over town about a drive-in hiring event. And, instead of going up and picking them up, which is what I've done in the past, is I called FedEx. And I said, listen, I'm the building inspector, I'm the zoning enforcement officer, you get these signs all over the place. I appreciate what you're trying to do, but it's illegal to put those signs up. And, can you have them down inside of 24 hours? And they say, yep, sure, we'll send somebody right out, we'll go pick them up. Sometimes, a lot of times it's a phone call and that's where it ends. And to be honest, I don't document that stuff unless it's a written request for enforcement. Sometimes there's other stuff that takes longer. I'll be honest with you, 101 Colburn, which was the site of a house fire about a year ago. They were also doing illegal body work and mechanic work. And, we've given them multiple opportunities to fix their wrong. We've written them tickets, all of that to no response from them. And we were forced, the town was forced to take the building down and clean up the lot. Okay, and we also have an injunction going out to them for the cease and desist for the car body and car repair work. Okay, that's taken 4 years. Okay, and again, that's taken significant amount of time. 1, 2, 3 trips to the courthouse. So it depends on the situation, and it's kind of a, how bad is it? How long do I think it's going to take them to clean up their act? What's the likelihood of them cleaning up their act? But we have to give them a fair chance. Hope that answers your question.
Thanks, Bob.
Okay, I'm going to move on to either Anthony, if you want to jump into signs, or if you don't mind, I was just going to pull up the moratorium and use variances. Do you have a preference? No, Anthony, can you hear me okay? He looks frozen. Is he frozen to anybody else or just me? I stunned him into silence. Okay, I'm just going to go then. Oh, Anthony, now it looks like you're moving again. Do you mind if I just jump into moratoriums and use variances?
Do whatever you feel is
Okay,
best.
great. Okay, so the next two bylaws I'll start with moratorium. So the planning board has been talking about, we obviously have this issue with traffic. We've had Amazon, FedEx, ADP Pile. We've had a lot of activity over the last year, a couple of years actually. So we've been debating the merits of a possible moratorium. There are two options that we looked at. Either do we need to revisit our definitions, or do we need something more extensive to go into some sort of moratorium, or we would have time to step back and look at the data, look at what we need to change. How can we better protect the town? Right now, our bylaws are not updated to where today's market is, or where we're going with e-commerce and all of the trucking and distribution that's going on. So we're not well protected. And I wanted to quickly share, I know we're short on time, but I thought this was really interesting. Amy and I met with CMRPC, which is our regional planner, and we tried to investigate more information so that we could share that with everybody and really try to provide information that helps us to make a decision on what's better, to look at the definitions or to look at a moratorium. In one study that they sent to us, I'm going to share my screen, and I'll send the link to everybody. It's really interesting. It's 64 pages. I'm not going to torture everybody to go through all of them. Can everybody see my screen with the it should say Amazon operational and planned Amazon. Is that where everyone's looking right now? Okay. So you can see, here, this actually was from earlier in the year. So that since then, more in our region has actually popped up. But you can see that Northborough is right in the mix with significant sized facilities, as we all know here, but showing up in this report as well. And if you take a look, you can see where we are here. You can see where they're popping up. There's more happening in the central Mass region, of course, over the last second half of the year. Again, I'll forward this to everybody so you can see. It's very, very interesting. They talk a lot about the trends and where this is going, and also taking a look at, sorry, I'm scrolling so quickly here. I just want to get to the charts. How you can see the explosion really happening over time, and it's really just continuing to trend upwards for both warehouses and these distribution centers as well. So things that we talked about, there's another section in this research report that includes what other towns are looking at to help protect them. And it's not just a matter of definitions, it's become a matter of what should you have in your site plans? What kind of conditions should you have? What kind of placeholders for mitigation should you have in place? All things that would help protect the town as we're faced with more, if we were to get more applications coming through for these type of centers. As I think both boards are aware, we oftentimes get applications where the tenant isn't named yet. So we're really we're struggling to figure that out. How do we best serve the town? Let's see, I'm going to stop sharing for a second, and I'm going to try to scroll quickly to the section that talks about some site plans. One thing that was in here that I thought was interesting as well is just looking at how one of these facilities can generate 1,000 trips a day, which can get really significant when you have more than one building. So certainly, I think just anecdotally, we recognize that there's an issue, but I think there's a lot of data to back that up. We also have we requested to get all of the information about our most recent traffic studies so we can show, what does that look like for us, and what kind of complications does that create when we're reviewing plans, what kind of conditions we can put in place to help mitigate that. So that I'm going to pull up the bylaw that everybody saw. I know, Amy, you said you may have had some modifications, but I'll just pull up what I have. I think it's the heart of it overall. And this is what I sent to the board. Whoops, I just want to share one window. Can everybody see this? It says path 1. Yeah.
Yes.
Okay, great. So this is, like I talked about, we said, do we need to either path 1, revisit our definitions? 2, do we consider doing some sort of moratorium so we can step back and take a more holistic view of what's happening in Northborough and what we need to put in place for our bylaws? Will definitions solve it, or do we need something more substantial based on where we are and sort of what's on the line? So I don't need to read this to you word for word. I don't know if Chairman Rand, you want to open to feedback or comments?
Okay, members of the zoning board, any comments? Susie?
Hi, I attended one of the things at the CMRPC. If I messed up the letters, I apologize. I'm listening to my kids in the other room, so I'm like trying to do two things here. I had attended one of their symposiums on the warehouses and in central Massachusetts, and listening to the different members of the planning boards and zoning boards from across Massachusetts, and the ones that had taken place had instituted a temporary moratorium. And I just want to say that I agree with it after listening to so many different people from all over. And I know some of you were also on the conference as well. But I remember that and being struck by how much information they gave us about it, and how I really felt that Northborough needed this at this time. Thank you.
Any other members?
Chairman Ren, Ms. Paul.
Paul, go ahead.
Just a question. When we had when Northborough enacted the duplex moratorium, what was the length of time that the moratorium for duplexes was for? Was it 1 or 2 years?
Amy or Michelle, do you recall? I think I wasn't on the board yet. Was it?
It was 1, and
I
I
believe
think
it was 1.
18 months is the max. There is a state max on the moratorium.
Okay.
And I think we usually do 1 from one town meeting to the next.
Okay. Thank you.
Yeah, I have a couple comments. What did the traffic study show? I mean, it hasn't been published yet, has it?
That's what we're trying to track down. We did the post occupancy study and realized that we didn't get a copy of it, but we had seen the presentation. And the presentation certainly showed that well, specifically in the Bartlett area. So obviously that's not our only industrial area. So we're trying to track down the official report and can share that with the ZBA as well. But in the presentation itself, it certainly supported that there's an issue in certainly the Bartlett area with traffic, just the intersections over there, especially. I think I don't think it was part of this report. I think in the past we've seen some accident reporting and things like that. So we can share, I'm going to write that down to share as well with the report.
Why is it necessary to have a moratorium rather than just study this and make decisions for the next town meeting?
Yeah, I mean, that's a great point. We could, if we think that we're in a spot where our bylaws can protect us, I think that's, maybe we can do the definitions, or I think I think Amy had suggested as an alternate, if we put forward the moratorium and then if it fails, we could have the definitions there as a backup plan. I think we need something in place. It's really difficult to, what worries me about waiting is that what happens in the interim as we get applications, and if we don't have something in place, are we missing an opportunity to strengthen our bylaws? I'm not sure. I know what we've been doing hasn't been working, so I'd love to find a solution that puts Northborough in a better spot.
I just wanted to say that most of this land is in the industrial, well, it is in the industrial zone, and it's been vacant since we've had zoning ordinances, zoning bylaws, and these people that own it have a right to sell it and make it productive for them. And they've owned it all these years. Why would we put the brakes on at this point in time?
Yeah, it's a great point. I think you have if Chairman Rand, if you want to call on any of your members for comments.
We have Brad. Any comments, Brad?
Yeah, so thank you, Mr. Chair. I mean, one of the things I think that we learned during the moratorium on duplexes is we just take a pause, we take a time out, and we can understand like what's going on, how this is affecting the town itself. And I know any traffic study in the last couple of years, it's going to be skewed because of COVID. Not as many cars, not as many trucks are on the road, things like that. So sometimes I agree with a moratorium just to take a step back, understand how this is impacting the town, good, bad, ugly, whatever. And I think we can just kind of level set and move on and make the best decision for the town as a whole, not just the Bartlett area or anything like that.
Well, when COVID arrived, it was only here for 2 weeks, and then we're into 2 years, and it'll be a long time before that works.
I
its
know,
way out.
right? It's gonna be over in 2 weeks. And now
Yes.
look at us. Yeah, 2 years, 2 years later.
Any other comments from zoning board members?
It's Fran,
Fran, go
just
ahead.
real quick. I don't necessarily think a moratorium is necessary. I understand that we want to make sure that we develop our industrial areas that in a way that is well suited for the town. But I think it's interesting to require a property owner a full year of waiting before they could possibly sell something to a potential developer. I think back when we wanted to change the demolition bylaws to prevent people from demolishing historical structures, and the town voted against having them have to wait a year while that was investigated to save these historical structures at the expense of the person who owned the property. So I think for consistency purposes, I would not be in favor of a moratorium preventing the landowner from selling it under the current bylaws.
Okay, Jeff?
I,
Jeff.
I agree on each of those points. I don't think a moratorium will specifically help. I think that the information that people have started to bring forward and some of the directional changes seems to be working, and I would still think that that is a better way to go.
Thank you. That covers the zoning board. Go ahead, Carrie.
Okay, great. Thank you for the feedback there. I will still send you some additional information. I think it's really compelling for all land use boards to see both the traffic and the report created. The report that I showed is actually the Metropolitan Regional Planning, but of course, Northborough was included in that as well. Okay, moving along. I have, can you see this? This is use variance here.
Yes.
Okay, great. So for this particular one, I think this is something that's come before in the past, and it certainly impacts the ZBA only. The reason I'm coming forward with it this year is because for a couple of things. First, we're one of the few communities that still have use variances. I think a lot of towns are moving away from it, especially towns that are in the middle of a master plan process. I think anyone who attended the recent special permit and variance class run by CPTC, there was a note in there that basically if you're running, let's see, I think I have it down here. So if you're still doing use variances, granting one likely conflicts with the community's comprehensive plan or the master plan. So I think that that's one thing, being in the middle of a master plan, it may be counterproductive to what we're trying to do in the master plan. The other part of it was really about, towns are moving away from it because it goes around the statutory procedure of bringing it to a legislative body to make changes in zoning. So if the town wants certain things in a certain area, it's in the bylaws. And this is a way that circumvents that by, allowing a board to grant something that hasn't necessarily been granted through the legislative body. So that was the second reason I think pointed out in this particular class, but also that we've heard over the last few years. So I'm sure there's a lot of feedback on this one. Chairman Rand, I'll let you open up to your board for feedback.
Okay, zoning board members, any comments?
It's Fran,
Fran, go ahead.
for the same reason that I just said before. I mean, property owners have the right to develop. If the variance is, a use variance is going to allow something that would not otherwise be allowed, the exceptions to the rules, it's not something that's granted often. I think that there is a history of not doing it that much. And in the same token, if we want to look at it that way, we shouldn't be redoing our zoning bylaws when we just starting a new master plan that may or may not be consistent with the master plan and the direction it's taking us. So I think you have to have exceptions to the rules, and you have to have a process for people to, or property owners to access or to develop with those exceptions.
Thanks, Fran. I would just like to say, I think the zoning board in the last 20 years has been very discriminatory about who they gave use variances to. And we looked at every situation, examined it, and, you know, there's things that come up that aren't in uses that are named in the bylaw, that a new industries, a new sciences, a new business types that aren't named, and you know, just something we never think of when you're making the master plan today, and it's going to cover the next 10 or 15 years. So, I mean, I think the use variance has a very significant use in Northborough, and I think it's used appropriately. Any other members? Jeff?
Just would agree with both with yourself and with Fran that is part of the role of the zoning board of appeals, and to have that flexibility to be able to look at the circumstances, and if they fit, be able to grant those variances for use, dimensional, and density. So
Just to clarify, this does not impact dimensional variances. This is just use, yeah.
I understand, just use variances.
Yeah.
Paul, Mark, rather? Mark? Mark Ratan? He raised his hand, then he disappeared.
Now I am. Can you hear me now?
I can hear you now.
Yes. Okay, in the 20 years we've both been on the board, we've seen enough use variances where we've had to use it as a situation to take care of what are very reasonable requests that are outside the rules. And yes, we've used it sparingly, but it's been extremely useful for us in giving reasonable relief under the regulations. I don't think it's been abused, and to get rid of it would shut off some very reasonable enjoyment of properties by people.
Thanks, Mark. Anyone else? Brad? Good. Brad, Jeff?
Got it. Yes. I mean, the use variance piece, I know Chairman Rand, Mark and Fran, you have a little more experience and seniority with this, but I mean, the use variance, the one thing that keeps coming back to me is the Northbrook Crossing. I mean, I grew up on that side of town. That was a wasteland. There was nothing going on up there. And we made good use of that space. It did minimal, I don't want to say damage, that's not the right word, but I mean, impacting downtown Northborough and things like that. Being on the board for over 10 years now at this point, I have not seen the use variance being abused. And I can't even think of maybe one or two other instances where this has come up. And growing up in Northborough since the early 80s, I mean, this is a town that's, I kind of say it's kind of a tweener town where we don't really know what we are. And we have different uses, we have different districts and things like that. And now Central Mass, we're part of Central Mass, we're inside Worcester, we're outside 495. I think the use variance could be helpful from time to time. And I want to hopefully think that the zoning board of appeals will make the right decision as far as the use variance. But I know this was kind of just a town as a crossroads between Worcester and Marlborough, and now we're growing up. And so I think this is good to have in our back pocket and not get rid of, because I don't see, again, just to summarize, I don't see us, we haven't used it that much. We haven't taken advantage of it, but it's something that we can hold on to for any type of good development for the town.
Any other zoning board members?
Chairman Ren.
Paul, go ahead.
Thanks. So I guess my question is, what other towns, surrounding towns have this rule also adopted? And like, what are there any? What is sort of the genesis of changing this bylaw in terms of taking use variances away? Is it just that CMRPC or sorry CPTC had it on one of their books, or how widespread are towns taking away a zoning board's ability to provide use variances to residents and businesses?
That's a great question. So I don't have the exact list. I think it's certainly something we could get for further exploration. What we're hearing, not just, well, me personally, not just through this one course, but through other planners, that it's an antiquated tool. And if we really wanted a use allowed in an area, we should just put it in our bylaws as an allowed use or special permit. So why make it a variance? If we keep seeing, we want this in a particular district and we keep having to do a use variance, do we just allow it in the bylaws rather than create why be an exception? Just make it the rule if we really want it. So the case has been made that you must, if you need to add it in there by way of a board of 5 people, why not go to the entire town, the whole legislative body, and say, yes, we want this use allowed in this district. So I think that was the whole reason behind it. I certainly understand what you're saying, and the Northbrook Crossing is an example of when we have used it in the past. I think Kathy had mentioned before, we could have still done it. It just would have taken several different, I don't know, magic tricks to make it work, but I think there was still a way to make it happen. But it's a great question, Paul. Can
I just follow up with one more?
Sure.
What is the impact on, say, an accessory use variance?
That's a good question, because I did notice that there are a couple of those in there. That's a great question. Bob, do you know the answer to that? What would be an accessory use variance is considered? Is that considered something different?
A use variance is a use variance.
And do you have something in mind, Paul, that you think that was some, like, can you think of an instance where that made sense and this would impact that? And I don't mean to put you on the spot if you can't, but.
I can.
Sure.
Yeah, I mean, I think, correct me if I'm wrong, Bob, but the case on Bartlett Street, Devereaux, wasn't that, an accessory use for in a groundwater protected area, right?
Mhm.
So, I mean, they were trying to, their main use was, the build the pipes or whatever, but they had the accessory use of being like a small engine repair type of thing. And, we, heard the case over 2 meetings. They went from groundwater. I felt like we did sort of the due diligence to allow sort of this accessory use or exception. I mean, part of the point of use variances or dimensional variances to sort of avoid the almost litigation of having to go in front of town for someone who wants to make a small change or to do something with their property that may not be allowed in the area. They can go in front of a board very easily, very cost effectively, make their case, right? And obviously it's a board of people in town. So, I mean, that's the purpose of what variances are there for. But yeah, I guess my initial thought is that I would probably need to see the full impact of what this would be, to be honest.
It's through the chair back to you, Paul. In terms of use variance for the main use or an accessory use, a use variance is a use variance, and I don't think there would be a distinction between the two.
Okay. Thank you.
Thanks for pointing that out.
I'd just like to point out too, in the past, Northbrook Crossing, when we gave that use variance, I mean, that was as a result of a meeting between the Board of Selectmen and the Planning Board to decide that route for Northbrook Crossing. It wasn't something that the zoning board went out and did on its own. Its own 5 members made this decision. It was basically the leadership of the town made a joint decision before it even moved in that direction. So, the use variance is used appropriately, I think, throughout the years that I know of in Northborough. Maybe in other towns it's been abused and it needed to be changed, but here it's not, it's working. Fran, go ahead.
All right, through the chairs, just, I mean, just as an example, just if you're familiar with the Grange Hall on School Street, it needed a use variance to allow for 4 units, 4 residential units to be put in that building. That building wasn't going to be used for anything else, but it did require a use variance in order for that to happen. And the last I saw, the towns of Ashland, Holliston, Hopkinton, Southborough, Westborough, and Shrewsbury all did have use variances. I'll have to verify whether they still do, but they did in the recent past.
Thank you.
Mhm.
Any other zoning board members? Susie? Go ahead.
Sorry. I do see the other side of it where we're getting this master plan and we don't want this. We've spent so much time on it and all of these meetings to set up to help, as to paraphrase Brad, help our town grow up and get into the new era as this whole area is growing from Worcester to Marlborough and out. And I can see how the use variance in its existence could be used to kind of disregard the master plan. So I do see the other side of it as well.
Hey, thank you. Anyone else? Back to you, Carrie.
Okay, so other than that, sounds like wide support on this one. Okay, great. So actually, that's the end of this one. I think all we have left, planning board, correct me if I'm wrong, the signs bylaw. I'm going to stop sharing. Is signs the only one that's left?
I believe so.
Oh, I'm sorry, Fred, did you have anything you wanted to share with the floodplain district, or that's not?
I wish I had something to share with you, but I'm still working on it. It's a little more work and complicated than I had anticipated, but I still expect to have it ready for you to bring to town meeting and be part of your public hearing process with the other zoning articles. There's a little more fine tuning I have to do with DCR, who oversees the program, and they have very specific wording. And I'm trying to make sure that it's not redundant or I'm not eliminating anything that we had in there before. So I apologize, it's not ready once again.
That's okay, but for the benefit of the ZBA, do you just want to quickly describe, it's just really catching up with federal? That's my understanding.
Yes, so maybe within the last 10 years or so, we have modified the floodplain portion of the zoning bylaw a couple of times at the request of the DCR, which now oversees the Massachusetts version of the National Flood Insurance Program. It allows homeowners who are in a floodplain and their property has to have insurance to get it at a reasonable rate. And this allows the building inspector and I to review plans when somebody comes in and proposes a structure or use of a property that's within the floodplain, to direct them to one of the boards, I believe it's the ZBA, to issue permits on that. But it spells out more and more detail of what the applicants are required to submit. The very short version is they're delegating a little bit more of their work to us to do at the initial level, rather than them trying to catch up at the end after something's happened. So it's the bottom line is that if we adopt this as requested, it allows the residents of the town to still maintain flood insurance within Northbrook.
Thank you.
Okay, thanks.
Anthony, sign bylaw.
Okay. I could throw this up here, but I think I'll just speak to it as
Okay.
well.
Do you want me to pull it out?
I think I have it.
Oh, okay.
Do you see it? Do I get the right one there?
Yes, but it's really small.
Oh, I don't know how to do that. So, all right, why don't maybe Amy, if you want to try bringing it up, but I'll just speak to it. So this bylaw, primarily what we're looking to do is prohibit internally lit signs in the downtown district. as well as residential, Main Street residential. The purpose is to add more consistency to the look of town. If you go back to the surveys back in the master plan, the number one issue that people had out of many was the look of downtown, and they wanted, the downtown improved. So to give you some definitions, an internally lit sign are the plastic signs that actually are lit from behind. And so very common, like where Rocky's is, or Pickle House Deli, those are internally lit signs. And then what you'd only be allowed to do is have an externally lit sign, which means it's a static sign that's lit from usually the front, static lights facing the actual sign. First of all, everything is going to be grandfathered, so nobody's going to have to rip out and replace their signs. A lot of these signs will probably still be around, and if we pass this, will be around in 20 years, the internally lit signs. The other thing we did is 2 years ago, we passed electronic message centers. We prohibited them all on Main Street. And it made it into the bylaws, but it was kind of confusing. We just cleaned up the language on that to make it just more specific. So then you might ask, why do we want to do this? So if you look at all the surrounding towns around us, and I'll start with Hudson, who just won a national award for the best Main Street in the category of Road to Recovery. They have this bylaw in place where there's no internally lit signs allowed on Main Street or their historic district. Westboro, same thing, downtown Main Street, no internally lights signs in their downtown. Southborough, same thing. Shrewsbury, same thing. We also found, just after looking to other bylaws, Millbury, same thing. And then if you look at some of the new construction in town, newer in the last 10 years, like where Lala Java is, 293 West Main Street. Looks great looking building. Signage is all externally lit. If you go down there at night, it's all very clear. It looks consistent and nice. Across the street, 169 West Main Street, newer construction, all the signage is externally lit. Looks great. 130 Main Street, newer construction, all the signage, so all externally lit. So it's a trend. And I think, just one little step in trying to bring some consistency to our downtown. I think it would be something that we don't have to wait for the master plan implementation committee. And just be one thing that we could do to start the process, at least to getting at least the signage consistent. The one thing I originally had said is I wanted that from all the way east business to west business. And today I decided, after talking to some different folks, the input was that might be an overreach for those areas. So I thought that's probably right. And maybe we just stick to the downtown area, which would include Main Street residential, there's not many businesses there anyways, and then just the downtown district. And that's primarily it.
Okay, Chairman Rand, do you want to open up to feedback from your board?
I have one question. Why would the design review committee be looking at signs?
Is that one of your additions?
Oh, yeah, that was one of my additions. We talked to Bob, he was okay with it, but a lot of towns do, but design review used to look at signs, so I don't think it's anything out of the ordinary. It's part of the site plan.
Seems like an added step that businesses have to go through. It's unnecessary. Any other zoning?
It was a 30-day turnaround, and if they have to go through design review anyways, if the sign is part of it, then it will all come to light earlier. I mean, Bob will be at the meeting with design review, and a person from the planning board would be, and the sign would be part of the site plan. So it'd be just a chance to talk about it ahead of time. And they used to.
In that context, I can understand it, but if it's a going business and it wants to change their sign, marginally, add some words or something, then it's got to go through this process and go through design review, which seems like an added step that's unnecessary.
That only be, downtown is the only place where it's new for changes. So I'm trying to think, if you're doing a new sign, there would be non-conforming signs in the downtown that would have to now be externally lit, so that would change. Any new sign has to come in front of, if there's a new business, they come in front of the planning board anyways and design review.
If it's an existing business and they're just changing their sign,
Yep,
this process kicks in.
right.
Bob, you have something too?
Yeah, this is probably anecdotal. I don't have the exact numbers, but probably 90% of the signs that I permit have absolutely nothing to do with any kind of a site plan or site plan approval.
Are they
Okay.
big or small? I know a lot of times it has
All
to
of
do
the
with square foot.
signs, all of the sign applications that come to me adhere to the dimensions that are currently set forth in the zoning bylaws according to where they're located in the town. Okay. So, the other thing is if it goes to design review, I would recommend that they go to design review first before they even apply to me, because once I get an application, I have 30 days to deny it or issue it. Okay, and design review is going to put the 30-day time clock way out of whack, and I'm going to be faced with having to literally let them put up the signs, because if I don't issue something within 30 days, it's considered to be an approved permit and they can install it. So if you are going to go the route of having all signs go through the design review committee, it will have to be completed and approved by the design review committee. But then again, does the design review committee have the authority to approve or deny on anything? I thought design review committee was advisory only.
Right, they are.
Correct.
So you can't, so the design review committee would be, it might have a voice, but it wouldn't have any power.
Thanks,
Yep.
Bob. Any
Well, I
other
am-
zoning board members? Fran?
I do appreciate the fact that Business East and Business West came out, because I do think the lit signs are helpful when cars are traveling at the 45 miles an hour. I like the idea of a downtown being a little softer. We don't really know what our downtown's going to look like, even geographically where it is, because that's in conversation. But there's a lot of pinks and blues on here, so I think it's more than just backlit signs. And so I think, and I know that there was a newer rendition, I think, that came out this afternoon, so I might not be looking at the last one, but there is a place in this that says any non-conforming sign which is removed or abandoned for longer than 30 days or destroyed by more than 35% shall not be replaced unless it complies with this bylaw. So that would affect, if allowed, would have a negative effect on the grandfathered signs that are there right now. And then there's wind-driven, whirling and spinning signs. So I think that this has more than just the backlit, but until I saw a cleaner copy or a more updated copy, I can't really say what the final bylaw would be.
Any other
Right.
zoning board members? Paul? No?
Sorry, I don't really have an opinion or comments.
Okay, anyone else on the zoning board? You're not seeing anything? Carrie, go ahead.
Okay, well, that's great. I think that is the final list. I took some notes here. I think the planning board has some further discussion on all of these. Amy, if you don't mind, stop sharing for a second.
Okay. I was just gonna say, I did have some changes, but it's line by line. I don't think the CBA doesn't want to go through it.
No. So anyway, thank you. I appreciate on behalf of the planning board that we have this opportunity to get together and talk through some things. It's good to hear different perspectives and how it impacts different boards and hear different opinions. So I think that's great. If there's nothing else, if you want to adjourn your meeting, the planning board should stay on because we still have the rest of our meeting.
Okay, you hear a motion to adjourn?
So moved.
Fran, second?
I'll second.
Okay, Mark seconded. Okay, we'll just take a poll. Fran,
Aye.
Mark,
Aye.
Paul,
Aye.
Brad,
Aye.
Jeff, Susie?
Do I get to vote? Aye.
Sure. Okay, the zoning board meeting is adjourned. Good night, everyone.
you.
Thank you.
Thanks so much.
Bye.
Thanks for
Thank
the
you guys
opportunity.
very much.
for coming.
Thank you so much.
Thank
Really
you for
helpful.
having us.
Bye-bye.
Good
Thank you.
night.
Okay. All right, I think we still have everybody here, so why don't we regroup? And does anybody, do you want to take a, are we good for time? Does anyone need a few minutes? We good? Okay. I'm just pulling up the agenda. I think we're just going to go straight into bylaws. There doesn't appear, there's nothing else on the agenda that I think we need to cover first. I'm just,
Carrie,
yeah.
I,
Fred, you're muted.
thanks, Amy.
Yep.
I do have a bond reduction that I've been working on for the developer of the Clarkwood subdivision and would like to talk to you about it if for a few minutes, if you have time. If not, I can put it on the next meeting. I didn't, I just finished it up today.
Okay, does it have a time limit or anything?
No, there's no time limit.
Okay. Is it something that, did you send to the board? Sorry, I've been working off my phone.
No, actually, I didn't send it because it was getting close to the time the meeting was gonna start and I didn't want to just throw it at you. I can send it to you. We can talk about it at the next meeting. It's fairly straightforward, but it's up to you.
Okay, great. If you wouldn't mind sending it, and then if we put it on the agenda, the first meeting in February, would that work for whatever timing?
It will.
Okay, and then if we have extra time tonight, we'll cover it if the board's okay jumping into it. It's on, you mentioned it was straightforward, so.
Okay.
Okay. Other than that, I don't see no A&Rs or anything, Fred?
No, there is not.
Okay. All right, so why don't we get through these bylaws then? Going back to brewery. Do planning board members have comments or questions on Amy's presentation?
Do you want me to pull up the use table or anything?
Sure, that'd be helpful.
I'll pull up the. Let's see.
Amy, I have just a quick question on breweries. Was there any discussion about what might have to happen with any types of other regulations like Board of Health involvement or any other types of management that they need?
Hudson did mention that, the building enforcement officer would get involved and the Board of Health would get involved, but that's all what would happen on other, facilities as they're being approved. She didn't say it would have to be anything that's in the bylaw, but she did say in her town, the fire chief, the building inspector, and the Board of Health all come together and work with the microbreweries as they come in. I didn't get into detail what they do with her.
Okay, the only reason I ask is because I have looked a little bit into some of that, and I do know that oftentimes areas that are storing grain, breweries and other types of large grain storage area have significant problems with rodents, and they have to really undergo a much more rigorous rodent management system. And you certainly want to give them a heads up if that's something they're going to have to be looking in before a bylaw goes in that says, oh, by the way, we can do this, but we don't have a way of managing it.
Yep. It's probably similar to a restaurant. I know you said it's more detailed, but.
Yeah, I think it would be similar, but it may be more specific towards certain issues and problems.
Yeah.
Sure. Okay. Just
But
curious.
Hudson has 2 or 3, and she said they haven't had any problems with any of the boards, with any of the residents.
So no, I was
I
just
asked her
wondering if
so
they
many
had things-
questions.
Yeah, if
She's like,
they
you're
had-
overthinking it.
if they had things in place prior to, then they might be preventing the problems. I was just curious.
Yeah, I don't know. She said they didn't change their bylaws at all.
Interesting.
Any other questions or comments?
Did anybody have any comments on what Mark said? Like, he said, why have a nano brewery and a microbrewery? I know Shrewsbury has both. I thought of that myself, like if you're gonna allow a microbrewery in downtown, you probably wouldn't have to call out a nano brewery because, you know, it goes up to 15,000 versus 6,000.
Would you mind scrolling to the definitions just so I can
Oh,
see
sure.
what we're even saying? Those the two are?
Sure, sorry.
Is there a difference in licensing for those two different sizes?
No. At least not that I know of. I don't know what happens federally. But as far as the farm license, the farm brewery license, it's all on if you grow your own ingredients or you don't, or if you buy them from Massachusetts.
Well, if you were a nano brewery, would you run into, if not permitted or prohibited, or you'd be covered under microbrewery?
If microbrewery was allowed downtown, then I would think a nano brewery would be allowed. But if you don't want something as big as a microbrewery downtown, then you might want to have nano brewery because it's only 6,000 barrels. But it does sound like, to Mark's point, and is if it grows too big, then they have to move anyways. But
So
I don't know, Shrewsbury put the nano brewery and the microbrewery both downtown. They left both definitions. Maybe it's good just to have the definition, so if you ever wanted to use them in the future, they're there. I don't know.
So can I give some feedback? Did
Sure.
we lose our chair?
Of course.
Are you still there, Carrie?
No, I'm still there. I'm still here. Mhm.
Okay. So I think if you're going to list these 3 breweries of 4 different types, you would keep the definitions in the definition section. I think at the last meeting, we did talk about how if data was coming in from other communities, that we would get that data from the planner of the other community in an email. So that's what I would be looking for. You also mentioned, Amy, in here, Westboro, Shrewsbury, Hopkinton, and Hudson. Maybe a good thing would be to show the planning board their actual bylaws. So we don't have their bylaws. We just have what you've cut and paste.
Right, but you could look it
Okay.
up if you wanted.
But this is your presentation to the planning board. So getting those bylaws is good, and then getting from the town, saying a conversation like, I talked to so-and-so and she said, do this. It's almost better to just find out from the town planners. For example, what you heard from the town of Hudson was, don't overregulate it. Keep it simple, don't overregulate it. Is that correct?
Yep, she said, don't overthink it.
Okay. So from another community, you might hear a little different, right? So these are conversations that you're having with them, and we need to make a decision as a board. Okay, so the other community is Westboro said, regulate it, but regulate it and be concerned about your parking. Is that correct?
That is correct.
Okay, so, it's good to look at the other bylaws, since you're presenting about what it is about them, because we could just go with don't overregulate it and do away with, as Mark Rattan suggested, the nano and microbrewery.
So this is my fault, actually. Amy did send these emails and I didn't realize it wasn't to the board. I need to forward it to the board. So we do have all of these emails from the planners. This is my bad. So I'm going to forward it to all the board members. And then if there's specific things you want to look up, you're more than welcome to look it up. I don't think that's Amy's job to call out bylaws for everybody, but these emails are here for everyone to review. I'm going to forward those as soon as this meeting's over.
Thank you.
So I have Hudson, Westboro, Shrewsbury, Hopkinton, and I'll send those all out to the board.
Thank you, because that's what we asked at last week's meeting.
Yes, Amy, I'm sorry. That's my bad, not yours.
Oh, no, I should have sent it to everybody. But I do think once you read the letters, I summed up what they said. And these definitions are what they have in the other towns, if you want to look it up. As far as looking at their bylaws and seeing where they place them, every town is different. It would be impossible. Like Hudson has like 10 different districts. They have like 4 different industrial districts.
Mm.
We just
Okay.
have to take the definitions and then put them in the districts that will work best in our town.
Okay, other comments or feedback on this one? Questions? Oh, Bob?
Yeah, thank you. Just a quick question, and I hate hypotheticals, but I've got to put this out there. Say, for example, we have a microbrewery in downtown, and it really takes off. And they want to rent a space or build a facility out in one of the industrial districts that has sewer and water. But they want to maintain the downtown presence. Can they build such a facility under these proposed guidelines?
I would think so. They could be a nano brewery downtown and then be a brewery, distillery, or winery in the industrial district, or even a microbrewery in the industrial district, depending on how much they want to brew. That's what Holden is doing. They started small in their downtown and they kept the tap room open, but then they built a larger facility in the industrial district.
Yeah, I mean, Treetop, I think in Charlton did the same thing. They started out not so small, but they got very popular very quickly. And it created a nightmare out there, to the point where they actually had to open up a second place down the Cape.
Yes, and there's one in Deerfield too. And they have a lot of land out there, so they bought a farm that's next door.
Mm-hmm. Mm-hmm. Thanks.
I could, I was looking into Treehouse, but they're just so different than us because they weren't sited in the downtown. They were often, I think it was like farmland.
Yeah, but the thing is that, when something gets almost out of control with its popularity, even with their big parking lots and their big driveways, they were still jamming up Route 20 for miles on each side.
Mhm.
And they don't serve food. And they don't distribute with trucks. It's literally people coming in, buying 3 and 4 cans or a couple of cases at a time. It's not a restaurant by any means. And, we don't have trucks rolling in and out except for their supply trucks, bringing, the empty cans and the materials to make the beer. So that's why I'm saying is that, you may fall into a dream situation where you start out with a nano brewery downtown and you wind up with a giant facility. The next thing you know, Anheuser-Busch is moving in down on Bartlett Street.
You can start with the brew pub downtown. That way, no more than 25% can be sold off site. It's more of a restaurant.
Yeah, I'd go broke.
Okay, so to close this out, I'll forward those emails. What do board members need to close on this one? Are we ready to close on this one?
Can I ask a question about the parking stipulation is that the typical one for the area or would that be applicable to both industrial, downtown business west and all throughout, or would it change with any zoning areas?
Well, that parking I went into our parking bylaw, and that was what is required for a restaurant. The only place, these aren't restaurants, so I had to apply some sort of parking. And industrial does parking differently. It's per square footage of the building. So that's something actually I was going to ask Bob or Fred to look into for next time. Like, that is what the Westboro town planner mentioned is, just make sure there's enough parking. And theirs is an industrial right now called Harbor, but it's also part of a strip mall that shares different, there are different uses there, and they just ran out of parking. But because they ran out of parking and they're growing, they're actually moving.
Right, but I was just, concerned about having 2 different parking qualifiers for the same zone that then has to be somewhat delineated by the use.
The parking is, Bob can explain but it's more by use
Oh.
than zone.
Okay,
Bob, do you want to jump in?
sure.
Oh, Bob?
Yeah, okay, thank you. In terms of the brewery over in Westboro, they're in that little strip mall, they're down underneath. Not only are they out of parking, they're out of tenants. I think there's one tenant up on that street level side of the building, and they're still out of parking, necessitating the move. In terms of parking for something in the industrial district, if you look at the current slate of uses in the industrial district, it's warehouses and offices and medical facilities primarily. Okay, what you're doing here is introducing potentially a new use into the zoning, into the industrial zoning district. Having said that, when you have an office situation or a warehousing situation or a truck transfer like what we have, you're dealing with big spaces and just a few people. Okay. If you were to have a big brewery with a tasting room, you would probably have to, work on the parking schedule like Amy's proposing here. That also being said, sometimes these breweries can operate with just 2 or 3 people in it.
Yep.
Okay, it's when you get into distribution, it's when you get into warehousing and labor for that, and also when you have any kind of a tasting room or any kind of a restaurant situation is when you really need to think about the parking. So if you're introducing a new use into the district and it's different than what we've been doing, which it is, I think the parking calculation is probably on the right track.
Okay.
I was even wondering if it should be one space for every 2 seats, only because, I don't know if it's more couples that go, or, I mean, they do bring families, but just because he was warning about parking, I was wondering, our bylaw right now says 1 space every 3 seats. I'm wondering if we think it could be popular, maybe 1 space every 2 seats. But that's something I was gonna run by you guys. Because the 1 space for every 2 employees, there probably aren't a lot of employees.
Well, the other thing is, if it's like you said, it's going to require a special permit and site plan review for this sort of thing in the industrial district. That would be the time to address parking. Have reserved parking set aside, and after a year of study or a year of operation, if you need to make them open up that reserved parking, you've got the authority to do it.
Yeah.
Allow yourself
Kind of
some
like with the
flexibility.
soccer.
Hmm.
With the soccer, we put a condition on if there were problems, they'd have to come back after a year.
True. Okay, other thoughts on this one? Are we close to the near final so that we just have a couple things to resolve, or any major opposition to this one?
That I can see.
Okay.
Do you think we should just do the brew pub in the downtown versus the Nano Brewery then? In case of popularity? I mean, downtown is a very little area, so I don't know how many would even go downtown. But we can leave it as a brew pub that's more of a restaurant if we foresee that there could be a problem.
Does that limit the size of the brewery to a nano brewery as well, or?
The brew pub?
Yeah.
No, I don't think it limits size. It just limits the amount of distribution.
Okay.
And I don't even know if it would make a difference. It's 25% of the amount of beer that they brew. So who knows how much they're going to brew. They can brew a little, they can brew a lot. So it might be more than the 6,000 barrels.
It very well might, yeah.
But I think the ones, I didn't ask the towns how many barrels, because I don't even know if the planners would know how many barrels that they're producing. I guess I would have to call the brewery.
Millie, did you ask that for a reason? Do you have?
Well, I was just, if you have a qualifier on the size, but not on the brew pub, then you could certainly find yourself in the same situation where you've got so much of the the brew pub being that successful in the brewery, that you kind of had outgrown or oututilized that space.
I think what Hudson does is, I didn't ask her this, but I know I've read it online. For all their restaurants, I think some of the banks are allowing parking, but you'd have to have an arrangement with local businesses.
Yeah, and that ends up with a liability issue. That's a generous arrangement for a lot of them.
Right.
So it can be a problematical situation.
I guess like Bob said, when it comes down to the site plan and special permit, we can look at parking and even, it limits the size depending on the size of the lot.
Mm-hmm.
And I put it as only by right in highway business, but we could change that by special permit. It all could be by special permit because it's a new use. If we think we need that. Would you do that, Bob? Would you allow it on highway business first? And would you do it by special permit versus by right?
I mean, for highway business, I would still probably want to talk about, maybe a special permit. And because, with a brew pub and you're serving alcohol, you're going to want to have the fire department involved, the police department involved, parking situations. I think there's town water down there, but there's no town sewer. It would have to be extended. So I think it's, to get something into highway business to that scale, I think it would be a wise idea to do the special permit. Whether it's planning board or the ZBA, I don't know, but it's, brew pub, it's like a restaurant, but you've got the added thing of with a lot of beer or a lot of wine.
Mm-hmm.
And I hate to say that, I might be overthinking it, but I would think you've got to get, police and fire and the town infrastructure involved, water and sewer as well.
Okay.
Breweries take an enormous amount of water and they take a huge amount of sewer.
Okay, does the board have thoughts on making highway business a special permit?
I think it's fine. A good idea.
Yeah, I think it's a good idea to also allow us to gauge a bit of what we're getting into.
I actually agree. I have a question for the chair. Is your goal tonight or next week when you vote on it, at what point are you going to send it over to staff, like the entire staff, to review these? Because what if there were additional changes to make? We're not just talking about engineering and building enforcement. It's talking like Board of Health and others when they discuss it. You're going to do it sometime in February or?
Yeah, as part of the public hearing process, we can send it over to all the different boards, and anyone that has comments and wants to weigh in certainly can. I don't know who's left on staff to share it with, but we can certainly share with anyone's welcome to access them or provide feedback.
Well, you have police, you have fire, you have
Yeah,
skilled
everyone's
people in
welcome.
administration. So you're waiting until public? Wouldn't you want to do it ahead of time in case there are some things that they know about that you're not thinking about?
Yeah, I mean, that's fine. Anybody can access them. I don't recall a formal process where we do that. So other than just, unless Kathy did that behind the scenes, I'm not sure. Maybe I'll get in touch with Michelle and find out what the typical process is and how that was handled and just follow suit. Unless Fred or Bob,
I don't.
Okay.
I believe that she had a pretty extensive distribution list for all the zoning bylaw stuff, so I'm pretty sure it went out to everyone, all the staff, to take a look
So if I
at it.
forward to Michelle, will she have all that on file or?
Yeah,
Okay.
we'll make sure that it gets around.
Okay, I'll send it over. I'll send over all the current status, where we are with all the bylaws after tonight over to Michelle, and then just go through whatever that process is. Okay, other comments on this one? So it looks like the only thing we need to settle on is whether or not we include all 4 definitions. If these are the standard definitions and, maybe we want to keep it open so we can fine tune it. Does any board member feel strongly about changing these, how we have these listed, or?
No?
Okay, all right, so why don't we move on? Amy, do you need anything resolved from here?
No, I think I'm good. I'll send you the final. I'll
Okay.
update those too, by special permit.
All right, and I'll send out the email to Michelle and the emails from other towns. Okay, moving along, we have the bylaws that Kathy had sent, so I'm going to pull those up again. Can you guys see this?
Yep.
Yep, okay. Okay, so this looks like the cleanup article. Does anyone have any comments or thoughts on this one, or is this ready to wrap up?
Ready to wrap up.
Okay, 37 South rezoning. Any comments or questions? Are we ready to wrap up this one as well?
Is George still on?
Nope.
I think it's good.
He was gonna get one other letter from
I think it's good.
the neighbor.
So I didn't see anything else come in, so I'm going to assume nothing came. Let me double check. I've been working off my phone, so I apologize for being a little disjointed on my emails here. Let's see. I don't see anything that's come in. So are you not, are you against this bylaw, Amy?
Well, I'm just gonna abstain until George gets the email from the neighbor.
Okay, so it sounds like Michelle's okay with it, Millie's okay with it, Anthony?
I'm okay with it.
Okay, all right, so we don't need to belabor this one. I don't think, it doesn't look like George is still on the line, but we can follow up with that. Next, we have moratorium, I believe. So I have that one as well up here. Hold on, let's see. Amy, did you say you had some edits to this one?
No, it was really just comments that I had put down.
Okay, all right, can I pull up the one that I had?
Sure.
From before? Okay.
Yep.
All right, so let's see. All right, so starting with moratorium. So we got, in addition to some feedback we heard tonight, let's see. Oh, I'm sorry, I skipped enforcement. We can get back to that one. It sounded like mixed on this one, mixed feedback. Questions about moratorium. There are a couple, we got some feedback of, impacts that would be, that impact that would cause. It seemed like a split feedback from the ZBA. Board member comments and feedback.
I think if you are going to do or propose a moratorium, I think you also want to maybe line up some of the things that you want to accomplish during that time with a moratorium. So whether it's, what's, I think people are going to ask, well, what are you going to do while we put a moratorium on it? So you're going to look for the traffic studies, or you're going to look for, I just think it's important to have things lined up as to what is the result, what's the desired result if you're going to do that.
Yeah, I couldn't agree more. I think to have an action list, if it were approved, what we wanted to accomplish and what timeframes would definitely necessary.
Okay, yeah, I suppose it's vague. We're not really, we're just talking about, we put together a group well, let's see. You're right, it doesn't really specify an action. That's a great point.
I don't know
Also,
if you
can
have it as
I wanted
part of the bylaw.
Geez, two people talking at once.
Sorry. Go ahead.
Carrie, I just wanted to comment on the past moratoriums with regards to solar, marijuana, medical marijuana, all those, there was no bylaw, right? So you weren't amending, it just didn't exist. That's why the moratorium went into effect. Just like Millie said, with regards to the multifamily, we had an action item on that. So you need an action items on these. And I think you keep on using in your language that you're looking for mitigation. You may want to check to make sure that you can even include mitigation in your zoning. Okay, so you might want to not use that language unless you're allowed to include it in your zoning.
Right, that's a great point. So I think what I'm trying to say is that conditions that would allow for mitigation. So if you have a certain condition in your special permit, that gives you an open door to put in certain mitigation. Like, for example, if you have something about sidewalks, just for example, then if you have something in your special permit that has to do with sidewalks and there's regulations around it within the permit, you could then apply mitigation related to sidewalks. And there's a valid reason for doing so versus we have nothing. Well, that's not fair. We do have we do have tools where we could apply, but I'm trying to think of what kind of things that we could put in place that would allow us to put in fair mitigation that wouldn't be contested.
I'm not quite sure you should be using the word mitigation. You might want to talk to whomever is advising you on that. You might want to use words like, for example, if you're creating the zoning, then what is the regulation that allows you to? So for example, this allows me to ask the applicant to install sidewalks, right?
Right.
Versus that's different than mitigation.
Conditions, maybe? Conditions also?
Conditions, exactly.
Yep.
Right, so I see that you're using that word a lot, and I don't think that's associated with zoning. If it is, you might want to ask who's ever advising you, wherever it is. It's more like conditions and regulations.
Okay, so that's a good point. I do think that needs to be clarified because there are, let's see, if I can quickly find it, I'll bring it up, but if not, that's okay.
I feel like you're getting your guidance from the Central Mass Regional Planners Association, so I don't know if they've guided you that way, or maybe it was someone else, but I just think if you're going to move forward with that, you need to make sure that's pretty clear.
Yes. Let me see if I can quickly find it. Amy, you had a point as well. If you wanted to mention something, I'm just going to try to find something while you're. I think you
Sure.
had a question.
For my comments, when we did the duplex moratorium, it was to get more time to slow down to come up with the appropriate bylaws, which is what I think you're bringing forth with the warehousing. We have 3 big warehouses right in a row, and you're just slowing it down so we make sure we have this right bylaws in place. And I think it's important to bring it forward just to let the people decide. You know, we're a board of 5 people. If they decide they want a moratorium to get different bylaws, and that's fine. If they don't, then we will add in the bylaws and we'll keep working on it. But I do think it's important to bring to town meeting just to hear what the people have to say.
Okay.
And I think we can come up with ideas, but I think until there's a study and you're working with like a consultant or working with Central Mass Planning, you don't exactly know what the outcome is going to be because they might know things that we don't even know right now. I think it's good to have some ideas for town meeting, but it isn't something you would add into the bylaw. You don't need it to push the bylaw forward to town meeting or to public hearing. But I do think for the bylaw, let me look up in my book. There's one section on transportation, but it has 2 different definitions. I do think we need to ask town council if it has to be 2 bylaws, or you can include both under one moratorium. So let me see. Under industrial, it is. Oh, distribution and transportation uses. So that's what the moratorium says, but it actually has warehousing and trucking and freight terminal underneath it. So there might have to be 2 of them versus 1 for both. That's just something I would ask town council.
Okay.
To make sure it's valid.
Excuse me, Carrie. I just wanted to speak to that because I did stand up at town meeting and speak to town meeting about the moratorium on the multifamilies. And sort of not really what Amy was saying. That's not really what I interpret would happen at town meeting. I think at town meeting, the residents were concerned about roof lines. They were concerned about more design standards. And what we got up at town meeting and presented, and feel free to go back and look at the video if you want, is that we agreed that we would come up with design standards throughout the year and then come back to town meeting. And so we clearly had educated the public about here what our concerns were, which goes right back to what Millie said. If you want this to pass a town meeting, you have to say, you know, here's what our concerns are. And that's what we did. We just didn't do this open blanket thing, what Amy was projecting was we had specifics that we spoke about at town meeting with design, with completing the design review standards, are working on that so the public knew exactly what our objective was, as Millie just mentioned to you, for 12 months, for that committee to go back and work on for 12 months. So that's what I think my feedback is, that it shouldn't be open-ended. It should not be. I think there should be some effort into it.
Okay.
Through the chair, through
Yeah.
the chair, we also looked at frontage and lot size. We met with a consultant after town meeting to discuss it all. I do remember the meeting talking about bylaws when we were in the kitchen at town hall when we made the decision to do a moratorium because we weren't ready yet.
Okay, so that's good feedback. It sounds like we have a question for town council on whether or not this needs to. We need some specific action items. And then just figuring out how to better articulate the mitigation piece of it versus condition, site plan, all of that. So those are the three main areas I have. Does that cover all concerns and questions? Okay.
Actually, I have one more question, and I think you can do it, but in the moratorium, it says we'll create a committee, like a subcommittee, that's gonna look into the answers that we're trying to come up with. I think that should be probably another question for town council, is
Okay.
the subcommittee, can it be created that way? I think it can be, because that's the action item that the moratorium's taking, is it's going to put a hold on warehousing for now and then create a subcommittee to come up with the bylaws that we need going forward. So that also shows that we're ready to move forward and get this moving. The subcommittee needs to be created within 30 days.
Okay, got it. Okay, I'm gonna pull up, let's see. So also use variances. So this was widely, the feedback on this from ZBA, that they overall did not support this. They feel that it's been used properly over time, and it's we should continue to having it. Any reaction to that or thoughts?
Just me again.
Amy?
I do think that, you know, I'm not gonna, when they brought up Wegmans Plaza as like, that was the biggest use variance ever in Massachusetts. But I think if you were with another town, that's probably not the way it should have gone. Like, for something that big, it probably should have gone through a town meeting, because that's a change of a whole zoning area. I'm not saying I'm for or against Wegmans, but for 10 to 12 people to have that type of decision on town is exactly what's pulled out of that book that says, you know, you're skipping over all of, you know, the due process that's supposed to happen when you're a town making those big decisions. And that's what the use variance does. I'm not sure about what to do for this year's town meeting, because it sounds like the ZBA really didn't want to see it go through.
Okay. Other thoughts on this one?
I'd be in favor of it, but I do think it would be a tremendous battle.
Mhm.
I'm actually opposed to it. I think the ZBA clearly showed you a roadmap, a historical roadmap of how it's been used to allow property owners to sell their property. And I think they gave you clearly good examples in the residential area, in the commercial area, and the industrial area, how it's all worked. So I'm not in favor of this. And I think many of the ZBA members were opposed to it as well. And they see it as much similar to where you have a toolkit for you to use. This is part of their toolkit to help the residents of Northborough. So I don't think you really can give any example at any point where it's probably been abused. They don't think there has been, and I think they want to keep it. So I'm in favor of it. And I agree with what Mr. Zeiton said. I think it's going to be an uphill battle for you.
Millie, do you have any? Oh, no, you may say your hand up. Millie, do you have thoughts on this one?
Yeah, I do. I think that people would be looking for examples of the use of a benefit to having a prohibition of the use variance versus keeping it. And I think really until you can convince people that there's a more significant benefit to it, I think it would be a hard sell.
Yeah. Amy, you had something as well.
Yeah, I mean, I took the class where they said it's a loophole, and I took a second class, which was economic development in the downtown. And they also talked about the use variance being a loophole. But I guess we can bring it up at the master plan. But I had a question for Michelle. Now, Michelle, you're the one who pushed for the use variance in 2012. What changed between then and now that you're against it?
I'm not in favor of it, Amy. That's all I have to say. I think the ZBA gave a really good argument, and a really good argument was brought forward at town meeting in 2012 as well. If you want to go back and read the minutes, you can. But no one was in favor at that time or the time before tried to pass. And I think you just had several members of the ZBA show you as examples of how it works in the benefit of the town, not against the town. So I think that's what you need to focus on.
So it sounds like there are some board members just straight against it. There are some that just think it'll be a tough battle. For me, I will concede to the majority of the board, obviously. I guess philosophically, I think a use variance prevents, if we wanted to allow the use, it should be in the bylaw as allowed, is what I get to in my head. And that if we're circumventing the town being able to vote on it to allow the ZBA to decide, I think what has been put out there is that that's just not, it circumvents statutory procedure in a way. And so that's what gets me a little bit. I think that say we have a board that they are implementing it the right way, it relies really on the people who are on that board versus there's no real set. It's very subjective. And in the times that I've seen it used, I haven't really seen the board go through a criteria that I understood to be the criteria. So that was something that had concerned me in the past. I'm philosophically against use variances, but if the board feels it's a tough battle and not worth it, then I'm willing to concede as well. I do think, I did hear what the ZBA had to say. For me, it wasn't personal to our Northborough board. It was more just about a philosophical feeling about the use variances. So do we feel like this is too tall of a mountain to climb, or?
I mean, I could see the pros and cons of having it or not having the prohibiting it. I think I did go to one of those CMRPC classes on it, and they were very convincing that the right thing to do, the trend is the getting rid of them. And I walked out of that class saying, wow, that makes a lot of sense. Streamline it, make it easy. But at the same time, I see how it applies in this town, and maybe it depends on the size of the town. Maybe certain size of towns really would benefit from it and others wouldn't.
Okay.
I think also you'd want to go back and, you'd have to go back several years and look at all the approvals and, make a case that, some of the use variances turned out not to be a good decision.
I guess one that comes to mind for me, and where you can see both sides, that's what makes this use variance decision so difficult, is there was a gas station on the corner, it became Cumberland Farms. And that was a use variance because it was a gas station, so it was grandfathered, but they wanted to change it. And they wanted to change it from going from a repair station to a convenience store. And in one light, you can say, okay, well, that's getting better, so that's good to do. And then in another light, when we talk about the downtown and the master plan, it was mentioned, well, that's a really bad place for a gas station. Maybe it should not have been approved by use variance, and just maybe it would have gone away and gone to a better use. So it has 2 curb cuts and it's on the corner there. So I see both sides of the, I don't know, of what a use variance can do.
I mean, I personally was vocal about One Lyman as a use variance. I did not think that warranted a use variance. I don't think that the criteria was presented. And, you know, so there are instances where I've seen it done recently that I just think was not a benefit to the town at all. It was, I thought it was detrimental to the town. I think if the town wants things and uses in certain areas, they should have the ability to express that or vote on that at town meeting, but.
And I agree with that too.
I agree with it too, but I do think it'll be a hard battle, but who knows? You bring it to town meeting and see where it lands, or.
It might be worth just bringing it and see what the discussion is that surrounds it, if there's a discussion.
Do we want to table this and then do some just additional research? And then to determine if there are many cases or not many cases that use variance were used and maybe should not have been?
Sure, we can do that.
Table it till February or till next year?
Till next meeting.
So February. I did pull some of the more, I know Kathy sent us a chart, so I think I have that on file. And then I pulled all the ones since Kathy sent the chart. So I'll look at that again and forward that to the board as well. Okay, I skipped over enforcement. I'm going to stop sharing. Amy, do you want to bring up enforcement? So from our discussion previously, it sounded like one action item is to send it by town council, which sounds like it may already be there.
I just would love to ask him some questions. Is there any way town council could come to our meeting, the next meeting, for like a half an hour, so we could ask them a couple questions about these bylaws?
About more than just this bylaw, or?
Well, I had the 2 questions about the moratorium too.
All right, so we have questions about the moratorium, this bylaw, whether or not just a general review of the bylaw, or I'm just.
I just wanted to ask a couple questions, like, you know, if to add D, is that really a benefit, a detriment, or does it matter at all? Like, why do the other towns have it, but we don't? And if it doesn't matter if we have it or not, why not just put it there?
Okay. And then the moratorium ones were whether or not we needed to separate by 2.
Yeah. And can that committee be created? I mean, I think it can be.
Okay.
I just want to see if it's valid.
Okay, I'll send a message over. Other feedback on this one or thoughts?
My question to it is just for this first part, for the enforcement. I know part of the enforcement request said, what we originally had was if the inspector declines, he shall notify in writing the party requesting such enforcement of any such action or refusal within 14 days. I was just wondering why we don't have the first part where if there is an action, then the building inspector shall give, it doesn't have to be immediate, we can change that. But he should give notice in writing to the owner. I know, Bob, you said you did it, but you know, I just wanted it to be in there. Like, I'm not saying you're leaving, you're not leaving. I know half the staff is leaving, but it's supposed to be a bylaw that could be here for years. And I just wanted it to be, in writing on the books on what any building inspector now or going forward would do.
Like I said before, what is written in the book right now is what I've experienced in many, many towns. And what you're saying literally just expands on something that's already been said. And it's actually, if you look it up, it's in 48. One of the things is, shall give immediate notice. I don't think immediate is a proper term because like I said, one of the things we try to do is educate people and give them a chance to comply before we go the enforcement route.
Okay, so Amy, the question was, I'm not clear on the question for this one. It's not about immediate, it's about just in general.
In general, like the end of the bylaw says that he'll send a letter to the person who asked for enforcement if there's no enforcement to be done. But what about the letter to the violator? There should be some sort of notice been made, like, so say someone's doing, I don't know what, but if Bob goes and does an inspection and the person is doing something wrong, then there should be a letter that you have, 60 days to meet with me and we'll work through this. The other towns I've looked at had both sides of the story, not just I'll tell the person who wrote me the letter that I didn't find an offense and I'm not going to do anything, but it had the beginning part where if the building inspector finds a violation, then he shall give notice in writing. But the notice in writing could say, I have 60 days that you have to come in and meet with me, and which I think you do now, Bob.
I've done that many times before, okay?
Yeah.
And like I said, every situation is different. Sometimes if I can knock on their door and have a chat with them, that's all it takes. But there are many times when I do write a violation notice and I give them, again, I tell them what they did wrong, how the complaint came in, and all the complaints are public notice. I don't take any anonymous complaints. I tell them who did it. I tell them what the violation was. I tell them where, and I give them the exact line out of the zoning code where they infracted. I also give them the ability to correct within a certain amount of time. Basically, I write the letter like I was describing before, so that if it does go to court and the judge wants to read it, it can stand up in court. It's not a friendly say, I think you're doing something wrong, you need to stop it. This is it's an official notice of violation, and I give them the opportunity to correct their violation or appeal, and I give them a certain amount of time. If they don't, and that's their warning letter, then I will start doing enforcements. So like I said before, this activity has been going on for the 10 years I've been doing this business.
All this bylaw does, though, is spell out that, a letter is sent. So I mean, I can see that it's just a regulation. It's like a bylaw regulation that it spells out what the enforcement officer is to do. And even if he's doing it or he's not doing it, it's good to have policy.
Okay, so it sounds like we want some clarification there.
Well, if it's not in writing, it's in 48 that's what happens. If it's not in the bylaw, that's all I want to
It's in
I didn't
48.
see any town that just had the last sentence
Well,
that the building inspector
Please
has
stop
to.
talking about other towns. This is
Yep.
Northbrook.
Bob, this is the planning board meeting. Please don't talk like that to a planning board member. Amy's asking a question and expressing her opinion on this. Okay. So we'll
Well, I
find
just-
out from
Sure.
town council what we need to do for this, if anything. How do we need to protect ourselves in a different way, or is it covered as is? So that's something we can certainly do.
Excuse me, to the chair, just to clarify, when you use, I've seen this in other towns or other towns are doing this, in order for any of us to make a reasonable decision on whether to approve this, it's always helpful to say, I've seen this in, like Amy did in some of her brewery one. I've seen this in Shrewsbury or Westboro or whatever, just to make the general, I've seen this in. It's always good to bring the data forward. I've seen this in this communities. Here's our neighboring communities. That's all I think is helpful when you say, I've seen this in other towns. We've talked about this well over the years, many years, about just talking about similarities with other towns and then stating the town.
Sure,
I
I
don't
can
think
make a
that's
list.
unusual to ask for.
Yeah, sure, that's fine. I think that's reasonable.
Yep, I can make a list of 2 or 3. I don't have the
Thank you.
time to go through all 350 towns.
Okay.
Madam Chair, I did see a hand raised in the audience, but I'm unsure if you're taking public comment at this time.
Oh, thank you. Why don't we wait? We'll hold off to the end for that. Thanks, Jim. Oh,
No, that was a mistake.
oh, okay.
Like, what's that button? I found out.
Okay, other board, so it sounds like we want some clarification from council on this. Are there any other comments from the board?
My question, Amy, is what are you trying to prevent, or are there examples of situations where the bylaw that we did put in place last year aren't working?
The only thing that was changed last year is where it says the $50, $100, and the 300. I think this enforcement part was the same.
Right.
Yeah, I was only changing it to, I don't want to say it because Michelle will get mad, but when I looked at all the other towns, and I'll get a list of them, they all seem to have both sides of the story. If someone notifies the building inspector, which we do in writing here, that there was a bylaw written that the building enforcement officer goes out and actually reviews the violation. And if there's a violation, then he writes a letter to the owner. And then he writes back to the person within 40 days if there isn't one. It's just something I saw over and over and over again. And I wondered why we don't have that. I was just trying to bring the bylaws up to date with what the surrounding towns were doing.
Right, but I guess my question becomes, is theirs working any better than ours? Is ours not working? And I honestly, part of me feels like I don't know that we always want to have something in such a written format or such a procedural element that can be kind of tedious. I mean, I can think of times when I may have had something that constitutes it as a business, a violation, and whether known or not known, I certainly wouldn't want to get just a written email or letter every single time something may or may not have come up, because I'd probably get more than I need. Because a lot of them are minor, or they're that I'm training somebody and they don't know something right away. I wouldn't want to get a violation written every single time something didn't go the way the Board of Health might say, oh, we need to do it that way. You know what I'm saying? So I don't want to get tied up in the tediousness of it.
I guess I was thinking of the bigger ones. I guess I didn't think of the little, infractions. I was thinking of more putting teeth into if there were big infractions.
Right, but you'd have to qualify that, I think.
Right.
Okay, so this probably requires a little further look. Any other comments or questions? Okay. All right, next we have signs, right? I think that's the last one, signs. So Anthony, oh, Amy, anything else on this? I'm sorry.
Yeah, I'll share my screen because I did have some updates.
Okay,
I just have to move where the people are on the screen.
okay, so right now the, oops, there you go.
Yeah. Okay. Okay, I can go through it line by line. I just have little things. If we're gonna do changes, but they're nothing major, some of them.
Okay, so is this the document that we last edited at the last planning
Yeah.
board meeting? Okay, thanks.
And then I think Anthony made changes, so I downloaded his too. Like Anthony had the original, I made changes to his, and then he made changes to the combined one, and he mailed it out today.
Okay,
So this is the latest.
okay,
And the first one's minor. I don't think you need the one there, but whether it's there or not, it doesn't matter. The awning sign originally, I crossed out permanent when I sent it to you because I was looking at, well, whether it's a permanent or a temporary sign on an awning, it should still be considered a sign, whether it's permanent or temporary. But as you go down lower into the bylaws, awning signs are actually prohibited. So it doesn't matter if it's temporary or permanent. So and once I went through everything again for like the 50th time last night, I realized it doesn't really matter if it's permanent or temporary because it's prohibited anyways. So, but originally I wanted both permanent and temporary signs to be noted. So banner sign, I added temporary because Bob mentioned at the last meeting that a banner sign is temporary. But you really have to read through like all 5 pages of all the little words to pull out that a banner sign is temporary. And so some of the changes I made were just adding a word here or there that it's temporary without having to read through 2,000 words. I also was updating flags because a banner, it says they weren't considered banners. So this is a question I have for Bob. If flags aren't considered banners, they're not really mentioned in the bylaw. So I'm assuming they're allowed. Anybody can put a flag up. But I thought for businesses, a lot of, you mentioned the national flags, the state and municipal flags and military flags. If you're putting flags up on a business, I don't know if you want to have the business flag because now that becomes a sign. Like say you're Burger King and you want to fly a 50-foot flag that says Burger King. Would that be allowed? Because now flags sound like they are exempt. And I agree, like national flags and state municipal flags and military flags should be exempt. But do we want a business to say, well, she wouldn't let me have a 100-foot sign, so I'm going to put up a 100-foot flag. And I guess that's a question for Bob. Are the flags exempt? Is that?
A flag with a business logo is not allowed.
Mhm.
A flag with a national, military, or any other political is allowed. Okay, because you get into First Amendment rights. And in the interest of me keeping civil, I will respond to a complete copy of this if you email it to me, and I'll respond in writing.
Oh, okay.
Okay. That'd be great.
Can I ask you quick little questions or you don't want me to?
Go ahead.
Well, it was just like, is it okay to take out the business then, or?
Send me whatever you, as a committee,
Okay.
have come up with. Send it to me, and I will address each item by item. Because
Okay.
there's a lot of stuff in here than just talking about illuminated signs. There's a lot of redundancy in here. There's a lot of stuff that doesn't make any sense. And you've got a lot of contradictions that you're proposing. And I would like to just put those in writing and give them to you all at one time.
Okay.
Perfect, thank you.
As we go down to erecting, I was only adding a dash because spell check told me to do it. I was defining flag because under banner, it says to see flag, but then when you went to flag, there was no definition. So Bob can answer if it needs it or not. The pennant sign, it says it's designed to move in the wind. And when we went down further, we talked about, don't want to make people dizzy, but down further, we talked about flags, or not flags, or I hate to move because I don't want people to get dizzy. But what I'm trying to get at is pennants aren't listed under any of the definitions or any of the bylaws. So I was wondering where pennants fall. And since it was designed to move in the wind, I was going to put it in the same location as the other items that move in the wind. So the wall sign included the parapet and the gambrel and the mansard roof. Those are parts of a roof, not a wall. So I wanted to ask the board if we wanted to move those parts to be part of a roof sign versus a wall sign. And maybe Bob or somebody why they were included under wall sign when they're parts of the roof. The window sign, I included decal, and this is a question I have for Bob, and maybe I can type up my questions if he doesn't want to answer it. But my question for him tonight was window signs and decals, are those included in the square footage calculation of a wall sign? I was just curious because there are some stores like that have stickers all over the windows and the walls, and are those considered as part of any of the calculations? Because I know we allow 32 square feet of wall sign, but I didn't know if window signs count towards that. It was just a question I had.
Oh, that
Since
makes sense.
since the last meeting, we were talking about internally illuminated signs. We were talking about illumination. And so I put in a definition for internally illuminated and externally illuminated. Because we had discussion on it. Maybe Bob can check to see if he agrees with them. I put in example box lit while I was going to describe it to people, but that is not actually part of the description. So I can take it out, but that's what I considered an internally illuminated sign, although there are other different kinds of them. So then one thing I passed over is at the top, there's an agricultural sign. And Michelle at the last meeting had mentioned that Davidians would be not allowed because it's in residential, but we actually have a definition for agricultural sign. So that wouldn't be a true statement. Any of the farms would be allowed to have a illuminated sign due to the definition of agriculture signs. They wouldn't fall into residential.
Amy, I would just ask for clarification on that because I was talking about their store. So we would have to ask legal counsel if that clarified that. So,
Okay, well, if I go to the top, agriculture sign is a
but
sign
again, I would just request as a board member that we ask town council for that.
Okay, so wait, Michelle, clarification on the agriculture as a store.
No. So you have Davidians, you have Barbarians, you also have Juniper Hills Golf Course. You have several businesses that I would have to go back and look, but that's just to name a few that are in residential areas. Right? And so let's just take Juniper Hill Golf Course, right? He's in a residential area. And so what Anthony is proposing here and Amy in their bylaw is that in a residential area, you would not be able to have a business to have an externally lit sign. Okay.
Yeah. And
So I suggested that they probably go back and take a look at that And that if for some reason a farm stand like Barbarians or Tugas or Davidians is covered, their stores that they have are covered underneath it, fine. But then you'd also want to look at the impact you'd have at Juniper Hills Golf Course, which is in a business doing it in a residential area. And then I didn't take the time to look and see if there are any others. You have a couple tree farms that are businesses in residential areas as well that may want to illuminate their sign, externally illuminate their sign, especially during the winter months when it gets dark out at 4 o'clock. So you might want to take a look at that.
At those businesses that are in the residential areas that would need a lighting at night. I know a lot of those are closed, but I don't know about I don't know if Juniper Hill is
Right.
in the
And
winter.
that's what, like, when I get down to it, the illumination in residential,
Yeah.
it talks about home businesses, and home businesses too are defined as fitting in with the character of the home. So I don't think that lighting them up at night fits in with the character of the neighborhood, which is the definition of the home network. And I did look at Andover and Westboro and Grafton and Hudson, and none of them allowed internally lit signs or even illuminated signs in residential neighborhoods. I could make a list of many towns. I didn't find one that allowed it. So it seems like it's standard across the board. And I don't even know if there are any in our town that are illuminated right now at night. I can't think of any.
But just out of curiosity, for example, Juniper Brook golf course has night events. They might want to have a sign that's externally illuminated. You said in here, you crossed everything out that said if it's in a residential area, even if it's grandfathered in, it's no longer allowed. And I think the zoning enforcement officer said that would not carry probably with the attorney general, that they do have a grandfathering clause in. Like I said, I haven't taken all the time to look at every single business in town. I just suggested, since you guys wrote this and put this in there and have already been advised by the zoning enforcement officer that it probably would not work, it would clearly impact a few businesses that I've already mentioned. Specifically, if you don't want to talk about the farms and think it wouldn't impact them, you would impact Juniper Hills Golf Course or any of the tree farms.
It wouldn't affect grandfathering, like the discussion about it getting knocked down by the AG. It's not eliminating any lawfully pre-existing non-conforming business. This has to do with the sign, and the sign would be grandfathered too. Like, it's not making anyone take down a sign that they have right now. It just says in a residential district, no illuminated sign shall be permitted. That's going forward. That's if, at town meeting, Fran was talking about a quilting business in a neighborhood. If that quilting business decides that they want to put up a lit sign at night saying, come get your quilts, they won't be able to, because, they're supposed to fit in with the home occupation and the character of the neighborhood. And it's just saying going forward, it's not getting rid of any signs that are there right now.
But you crossed it out, Amy. I just want to mention that you did cross it out. Are you saying it's now back in?
No, I'm not. It says in a residential district, no illuminated signs shall be permitted except when associated with an allowed non-residential use. That's except with a new one. That's not someone who's already grandfathered. It's not saying grandfathered doesn't count. Like, you can't take away grandfathered use. I'm not trying to take away a grandfathered use. And
But your zoning enforcement officer said that that's what you're doing by crossing it out. So again, I think we just need to send this off to Bob Federico and ask for his interpretation.
Okay, that would be a question for legal counsel too, because this isn't, I'm not trying to remove a grandfathered use, and that's not what this would do. But we can check with legal counsel.
Okay, I wrote that down.
Okay, thanks. So I'll go back up. Everybody close their eyes so they don't get dizzy. So we have the definitions for internally and externally illuminated. I can make a list of the towns, but the towns include a non-conformity section in their bylaws. So if you're trying to update your sign bylaws, any sign that comes new that isn't allowed in that district anymore would have to conform. And really the only one being discussed right now tonight is downtown. Downtown right now has internally illuminated signs, and Anthony brought forth that they now would have to be externally illuminated if it passed the town meeting. So those signs would be non-conforming. And 20 years from now, when the plastic breaks, they would have to upgrade to conform with the bylaw, but it's not something that isn't written in every other town I looked at, and I'll make a list. I went to Westboro, Hudson, Andover has a very extensive bylaw. I went to Southborough. So this is just the non-conforming section, and Bob and legal counsel could review it. A question for Bob I had was, it says billboard and similar signs. I was just curious what similar signs are, because it's a vague statement. I was just curious. Number 3 says no sign shall be part of or attached to roofs. I'm not sure. This is something that was added. No sign shall be attached to roofs. I'm not sure if we have any roof signs right now, but that's another thing that most towns don't have. They're not putting signs on the roofs. It may be more in a city, you know, where there's not as much room and people put signs on their roofs, but I don't even know if we have it. We talked about this last time, the wind driven, whirling, spinning, flashing. This is where I was considering adding pennant, because it says the pennants are wind driven and flap, but the pennants aren't actually discussed anywhere else in this bylaw. So there's a definition for pennant, but they're not anywhere in the bylaw. So I was thinking that we should add it here. There's no changes here. Then what the discussion was with the ZBA is the design review, and with Bob, how much do we want to go in front of design review? Should it just be the new signs for the new buildings? Because it would be tedious to have every single sign change.
Yeah.
So I'd have to go back and read this to see if that says more than that, like to see how we could do it where it's only the new signs as part of the site plan review.
I think that makes more sense rather than to do every sign or any change in signs.
Right. Yep. And this, I think Anthony talked to electronic message senders. If you look further down in the bylaw, they're only allowed in industrial and highway, and they're spelled out in those little districts, but you really have to go digging for them. And the first time we talked about this with Kathy and Bob, they're like, no, they're allowed everywhere. But then if you dig through, you see that they're actually not. And I have the minutes from 2018 when we reviewed this, and we specifically, you know, took out message centers from downtown business, business east, business west, and business south. And that went through town meeting. It's just bringing it up to a place in the bylaw where it stands out. This is the list of everything that's allowed and not allowed. This is what Anthony brought up tonight. Internally illuminated signs are prohibited from downtown business. Oh, this must not be Anthony's,
No,
because he had one where he had this crossed out. So this must not be the latest.
Okay, so business
You
east.
want me to
and
close
west.
it? I did have the latest up. You want me to close it and try to pull it out?
Is that one of the
Yeah.
only differences?
right, but I added, so I took out business east, business west, but then added Main Street residential.
Okay, so is this the really only the area of change?
Yes.
Okay, so then no, as far as I'm concerned, if that's it, then.
There was one other place though where you externally lit signs are still allowed in Main Street residential, but not internally. I forgot where
And
that.
I added the same allowed in downtown neighborhood.
Okay. When I get to that, we'll have to. This was here from before, but I think Bob brought up that banner signs are temporary signs. So that's why I added temporary in front of banner, because it wasn't obvious that there were temporary signs. So this will probably come out if temporary is in front of banner, because there's another space where they talk about temporary signs. Do you want to talk to this one, Anthony? The LED rope strip lighting?
Yeah, so that is new. So the LED ropes, there's a few businesses in town who have them. They're pretty striking, especially at night. And so I'm recommending that they are prohibited basically all of Main Street. I think, did we leave Business South out though? No, all the way down Business South. So that is an addition I didn't speak to.
This is one of my additions, signs painted on attached to utilities, poles, rocks, boulders, trees, fences, utility boxes are prohibited. That was, I did really review, and I did on the others too. I reviewed like 6 to 10 towns, and that was something that a lot of towns had. And we probably don't have that problem here, but does it hurt to add it? There are some places where they actually do attach them to fences. I've seen, just like the beginning, at the very purpose of the sign bylaw is to like not to bring attention to businesses without cluttering, because if you have over clutter, then it's hurting more than it's helping. And that's not my quote. That was the purpose of this bylaw written years ago. This is one thing I added. Bob can review. A lot of towns had historic signs, markers, municipal plaques. Are not subject to this bylaw and shall be permitted in all use districts without a permit. I don't know right now, Bob, if when people put up the historic signs in town, they need a permit, or the markers or the plaques, but a lot of towns have this statement that those are permitted without permits. But I don't want to undo something Bob might have, so he can reply to that. This was pulled from another town though, too, like 6 towns that I looked at. That if the person has left or they're not doing what they're doing anymore, that the sign has to be removed within 30 days. If it sounds too restrictive, I'm not sold, or it doesn't have to be there. It was just something I noticed a lot of people had. I don't know if we have signs that hang around after the use stops. So whether or not we put in that, I'm not sold on it. I was just trying to.
So a lot of times, I'm just curious on that, because a lot of times the owner of the business is not the owner of the property. So they're just renting that space. And so
Yep.
if the business goes out of business, they just leave it, because they leave it to the cost of the owner of the property. So when you say owner, are you saying the owner of the business or the owner of the property has to remove the sign?
Well, this says, it probably should be the owner then, right? If a lot of the places are leased, so say, I don't know, say it's over on Times Square and it's Dunkin' Donuts and they go out of business, then the tenant who owns it should probably take down the sign. Whether or not it's 30 days or
Former
60.
tenant, you mean?
I would think the owner of the property, if the tenant leaves it behind. Like even Bank of America has been closed for years, but she did take down the sign. So, but if it still said Bank of America there, you'd probably want that sign to come down within a specific amount of time. Not only is it up for no reason, but it could confuse people. People could pull in and say, "Oh, I'm going to Bank of America."
Yeah. I
You
don't know,
know.
if it's some of them, I don't know if there are some structural components to that, because I know a lot of times they just turn the sign upside down. They turn something upside down, so you know it's no longer a business, but it's still part of the aesthetics of the sign. I wouldn't want to see a sign with a gap in the middle. You know what I'm saying? You know, how you might have 3 or 4 signs on one sign.
Yeah.
And then one business goes out, there's a gap in the middle. It looks like missing a tooth or something.
I see that now, actually.
But a lot of times they'll just turn them over so that there's not a gap, but there's
Okay.
something. I'm just curious as to, with it removal within 30 days, I can understand why, but I don't know that that's what that would create.
Yep. Maybe with the freestanding sign, or I don't know. It probably was from a town that had problems where people were leaving and leaving signs everywhere. And
Probably.
saying the owner has a property, but the
Yeah.
sign's up forever, like Bank of America.
Yep. Yeah.
And her sign is gone, so I'm not pointing fingers at her. I just used it as an example.
Mm-hmm. Yeah.
Once the tenant's gone, maybe there's a certain amount of days where the sign has to come down. But, I'm not sold on it. I don't know what other people think about it. I just brought it forth because I did see it in a lot of other towns. I was just trying to, while I was going through the whole bylaw and comparing it with like 10 other towns, 6 to 10 towns, I can't remember how many now, I was pulling out things that were trying to not cause problems now, but, maybe take care of problems in the future.
Yeah, also that thing about 30 days, you'd have to know when the operation ceased. A lot of times who's keeping track of that?
Right. It probably says 30 days, but like if someone noticed a year later it was still up, you could say, well, it's been longer than 30 days, I don't
Right.
think it's someone that needs to have like a stopwatch or anything.
Right.
But it just sets some sort of a time, whether it's 30, 60, 90.
Yeah.
This one we already talked about. Bob's gonna get back to us, I guess.
I have a question. Are you actually still recommending to take out the language call attention to in a basic requirement paragraph?
Yeah, I don't know if that one really matters. Take it out or not.
Is that back up here? Not sure where that was. How far back was that, Michelle?
It's under D, basic requirements.
Okay. Close your eyes. I'm going. Okay. Yeah, if we're not sold on it, we don't. Like some of the things are probably brought up for discussion and we can decide as a board.
I think, yeah, I mean, I don't, the call attention to, I don't think it needs to be striked out.
My next question, there's a lot to go through here. There's so many things that are highlighted and then crossed out, so a clean copy would be good. But the other thing is, what's your argument for relettering under erecting? I don't understand that.
Where are you?
Under number 11.
Under basic requirements?
Yep.
Oh, no. Up further?
No, this is under definitions.
Okay.
Why do you think relettering needs to be there?
Oh, relettering was there. I just added the dash because spell check said to.
Okay, so that's where it's very confusing. You can't figure out what you've added and removed because my copy is all in blue and in yellow, and some things are crossed out and some things are added in. So I think it'd be helpful moving forward to get a clean copy. There's so many changes on this.
Well, I think what happened was Anthony did the original, then I made changes, I'm blue. And then Anthony said some other changes, so we can merge it all together. But right here, it was just added the dash. If we're gonna do changes, you can update the little things, but we don't have to. A lot of them are just housekeeping things. But the last one, close your eyes, was a question that I have. Talks about wall signs, and this happens in every section. When you have a freestanding sign, so now we're in, this must be in the commercial districts. Yeah, business east, business west, but it's also in downtown business and the highway. So if you have a freestanding sign, if you have one or two tenants, one wall sign not to exceed 32 square feet, or two wall signs combined total of not 32 square feet, which makes sense. When you go down to three or more, it says one wall sign not to exceed 32 square feet. And then it says for each tenant. So that means that if you have more than three people, now all of a sudden they get 32 square feet each. But when you continue on, it says, or two wall signs with a combined area of 32 square feet. So I think originally there might be a typo with the way it was done originally, because if you have two tenants, you can have up to 32 square feet. But then if you have three tenants, then you could go up to unlimited. Like if you had 10 tenants, now all of a sudden you can have 320 square feet, because each tenant's going to get 32 square feet. And why I'm thinking it might be a mistake is because it says one wall sign 32, and then two wall signs combined are 32. It doesn't really talk about three or more, except for, you know, if it says 32 square feet each. Like if you go home and think about it, or you can think about it now, it doesn't make sense. Like it should say one wall sign 32 square feet, you know, two wall signs combined 32 square feet. If you have three or more tenants, then each one maybe gets a smaller amount, or they total 32 square feet. It just doesn't make sense to have unlimited wall signs at 32 square feet each.
If I could make a recommendation, that's good to send on to the zoning enforcement officer and ask him for his interpretation.
Yep.
You may just not
Yep.
be understanding it, and he can help give you clarity.
I agree, but I also think as a board, we might have to discuss it too, because it could have some unintended consequences with some of them. I mean, this person can have up to 10 tenants. That's 320 square feet of wall space covered with signs. So, all right, those were all the changes I had. If it's easier for Bob, I could take this and take out all the colors and combine Anthony and I's changes together. I could send it out to the whole board and to Bob.
That'd be great. And then we have questions for council as well. So
And then to the chair, I just wanted to have the board consider this. There was ZBA made this comment several times, which is you do not have a defined Northborough. The master plan implementation committee is meeting and hiring a consultant to define it. So you're spending money to hire a consultant to define your downtown, but yet you're changing a bylaw where you don't know really where your downtown, the perimeters of your downtown exist. So I think you need to maybe think about that, as some of the ZBA members brought that for consideration.
sure. Amy,
Through
you're
the
something.
chair, for me being on the master plan implementation, wherever the downtown is, it's going to be the downtown. Like, so if you look at all the surrounding signs in other downtowns, it doesn't matter where they are, they're all non-internally illuminated. So whether downtown goes to the library or goes to Stone Motorcycle Shop, it's still going to be the new downtown. I don't think we have to wait for that.
So what if it goes all the way to Business West, Amy, or encroaches on Mill or Business East, right? And I just think it's worth considering, as people from the other members of the ZBA brought it up. And so worth considering for the board to think about.
Okay, great. I think that covers the full list. Did I forget one? Okay, Jim pointed out some hands raised. I will take public comments. If there are any, I have a couple here. Okay, Bill Pierce, I'm going to allow you to talk.
Good
Hi,
evening.
Bill.
Can you hear me?
Yes.
Thank you. I want to speak for removing the use variance. This town has spent a lot of money and time putting together a master plan. We have seen many times with items have either been put on hold or pushed off to wait for the master plan implementation committee to perform their work. Providing a mechanism to get around that process negates all of the time and cost creating and implementing the master plan. The use variance process also removes the voice of the residents of Northbrook. You are instead allowing a small group of unelected individuals to change what the residents of Northbrook have voted on by creating the master plan. It has been mentioned about that. It's been mentioned that the use variance was used to create Northbrook Crossing. What about allowing the Northbrook residents to vote on if they want to have a large shopping plaza or not? They obviously had no say when it was implemented. You might mention that residents have the ability to write letters or make comments as I am tonight. After seeing what happened with the Southborough after school program being eliminated with all the public comments and letters that were written in support of the program, it's easy to see that the letters and public comments can be ignored by boards and committees. If you don't believe in the master plan, then you would need a process to get around it. If you believe that the master plan is the way for Northborough to move forward, then you should abide by the implementation of the plan. That starts with removing the ability to have a committee or board make a use variance. Instead, allow the residents of the town to vote on any changes to the zoning bylaws. Thank you for allowing me to make comments in support of moving this forward.
Great, thanks, Bill. Okay. Scott Rogers. Hi, Scott.
Hey, good evening. Thanks. Scott Rogers, 26 Tomahawk Drive. Just wondering, what meeting do you forecast to have the public hearing on the bylaws? What do you think the schedule will be?
Yes, let's see. Probably end of February, beginning of March. I think we've done them really late before. I would say definitely not the next one because we still have to finalize them. They're due on the 3rd. And then we usually have the ability to edit as needed. So I think maybe that second meeting in February, first meeting in March.
Okay, great. I'll keep those free. Thanks.
Oh, good. Great. Thanks. Okay, Rachel Armstrong.
Can you hear me?
Hi, Rachel.
Hi, Carrie. It's Rachel Armstrong, 10 Hemlock Drive. I wanted to discuss the warehouse moratorium. I'm not sure if the ZBA is aware. When we checked in with Kathy Joubert, we learned that there are 250 acres of undeveloped industrial land still in town. That does not include Bartlett Street. Bartlett Street is probably as developed as it can be at this point, but it does mean that all of the issues that Bartlett Street has been facing will now be in other parts of town. I know you are aware that the impact of the warehouses has been very significant in a pretty negative way for the people in the area and for the town as a whole. The planning board conditions can't be enforced. There's some confusion as to whether the zoning officer needs to be there or whether residents can submit violations. We obviously have validation from CMRPC based on accident reports and a traffic study that the area is unsafe. We have twice what we would need for a truck exclusion, but we can't get it. So basically all of these issues can't be resolved. I'm not sure why we wouldn't take just a pause and a breather and have a moratorium to see if we can come up with some solutions before we open it up to other parts of town. You know, as a resident, I can tell you, we are inundated, and it's not something that I would want another part of town to experience when we have very little control at this point. Once the warehouse goes in, there are lots of other uses for industrial zone. If you drive down Forest Street in Marlborough or even on Cedar Hill, you can see a lot of other industrial developers that aren't warehouses. The soccer field that just went in is a great example. So, you know, we aren't walking away from that revenue for whatever the moratorium ends up being. And certainly once the moratorium ends and we have better solutions, e-commerce will still be there. So I did just want to, you know, put my 2 cents in regarding that. Thank you.
Okay, great. Thanks for sharing that. Lisa Maselli. Hi, Lisa.
Hello there. Hello, staff and board and everybody. Lisa Maselli, 13 Maple Street. So I have a couple of comments. The first thing is just like I think it would be a office or secretarial thing. When you have building inspector instead of enforcement officer, aren't you asking that it's the enforcement officer, not the building inspector for zoning? So when we use those references, I think it changes. Okay. Now, second thing, taking out the interlit signs in Business East affects me greatly. And I think it should be in Business East and Business West, because it's part of what we're going to try to start making our main street look like. And that would be a little bit softer, a little bit more rural perhaps, but I think it's very important that we start moving towards some sort of concise look, you know, similarity that isn't just blaring and you know, it's the Wild West right now in town with signs. So I really think it doesn't hurt the people who are already here because we're grandfathered, but I would like to see that go back in, not just take that out. I don't know how many people talk with you today, Anthony, but I can certainly get a few more people to talk if you give me a number. Okay. In the question of the design review, looking at signs before they go to the zoning officer, that worked. He said that would work for him the last time. I think that would work great in the fact that we would be able to get to see what the sign were going to be, and he would then enforce what the sign is going to be. So a lot of towns I've been involved in doing that in other towns because of being a person who does products with your name on it. So I speak from experience on that. And again, you know, when you're driving downtown, we want to have a nice look as we go down our main street, and it's along Main Street. I guess in the last one, I think I just have a question. And unfortunately, it's not a bylaw question, but I noticed that I heard that 101 Colburn Street had been demolished, a part of it, and the town had done it with an RFP. And I wonder how that happened if that was private property. Because if there's something that we can do to create kind of a cleanup like that, it'd be nice if we could use that on the Ridge Road property at the peninsula. So there you go. I'm going to let the rest of you have a good evening, and thank you for listening.
Thanks, Lisa. Fred, do you know if that was for demolition on Colburn? Is that something that we normally could enforce in other areas? Could we apply something like that to Ridge Road?
I don't believe it's applicable to Ridge Road simply because there's nobody living there on Ridge Road, and somebody was living at 101 Colburn Street. It's not really my area. I know that town council and the building inspector worked together. They went to court, as Bob indicated, several times, and had to do with non-responsive zoning violations. But beyond that, I don't think it's applicable to Ridge Road, but I can't
Yeah.
speak to it more than that.
Okay, all right, I have one more comment here. Oops, Janine Callahan. Hi, Janine.
Hello, can you hear me?
Yes.
So hello, everybody. I just wanted to also comment about the warehouse moratorium and that I would be in favor of it. Living here over on Stirrup Brook, I see the impact that warehouses have on our town, not just because I live off of Stirrup Brook, but because I see what's happening with the 18-wheelers that are using our town to get to the major highways. And I don't think that a moratorium is such a bad thing. As people had stated, tapping the brakes a little bit is not such a bad thing. We aren't able to enforce the special permits that went into the buildings such as Amazon. Nobody seems to be following the rules. So to me, it just kind of makes a lot of sense. E-commerce, as we all know, is moving at the speed of light. And unfortunately, Northborough is not moving at the speed of light to keep up with the way that these companies are moving into this area and progressing and building and becoming huge. And they are basically taking over, and we need to learn how to work with them. I'm not saying that warehouses are awful and shouldn't be in towns, but we need to learn how to work properly with them. And right now, I don't feel that we are, and they're completely, in my opinion, taking advantage of small towns like Northborough. So again, I think a moratorium and tapping the brakes a little bit is a fantastic idea. It's not forever, but it helps us learn, and I think it can be nothing but a plus for the town. Thank you, everybody. Have a great night.
Okay, thanks,
Thank you.
Janine. Okay, thanks everyone for the comments tonight. Any additional comments from board members before we move on?
I do, Carrie, just moving forward for the next 2 February meetings. I just think in all fairness to the residents of Northborough, if you're going to allow public comment, you should advertise it as such, so that if people have concerns about other things, they can weigh in. Because if someone on the committee is going to make a decision about what a public had just said, based on what the public has just said, they may not have heard from all the members of the public because it was not advertised as such. So I think if you're going to open it up, you should open it up or let people know in your next 2 meetings it's open to the public.
Yeah, I would love that. In the beginning, I had originally proposed we put public comments on our agenda, and Kathy at the time didn't think that we should. I can't remember why, but in any case, I'd be glad to do that and accept public comments. That sounds great.
I'm just saying it's in fairness to all the residents of Northborough, not just ones who are selectively invited.
Well, it's on every agenda that people can call in. There's a password.
Yeah.
So, I mean, that's what I've been told before, like when I asked about an abutter, like an abutter like within 300 feet gets noticed. And I've been told that if you're really concerned, then you look at your agendas and you attend the meetings and call in. I was told that in the past. So I'm not saying it's right or wrong, or not saying you should advertise or not advertise, but
I'm happy
I'm
to
just
accept
saying
public
what I've been
comment.
told. And the people who watch the agendas came here tonight and spoke, so.
Okay, well, plus we have the public hearings for bylaws too. So for anybody who is watching this meeting recorded or catching it later, there'll be an opportunity for everybody to call in and comment. All of the bylaws will be part of the hearing process, which does require public comment. So, and certainly for anyone who can't make it, letters are welcome as well. So you can send in letters to the planning board email, and all members of the board get to see that. Okay, great. The last thing, so we also have minutes. I did not get a chance to read the January 4th minutes. If everybody else did, I can abstain. Did everyone else have a chance to read the January 4th minutes?
I did not.
I did not.
Okay, so why don't we table those minutes? We don't have a majority for that one. Fred, we were talked about doing the bond for next time. Do you want to try to squeak it in or we'll do it next time?
Whichever the board pleases. Either way, I can send you the letter, give you an update, or we can do it at the next meeting. It's up to
Any
you.
preferences from the board?
Next time.
Next time.
All right. I
Okay.
tried, Fred, I tried.
Thank you, appreciate it. I will send you the email tomorrow, and I'll send a map along with it. You can look at it.
Okay, that's great. I think that's it. And did I miss anything? No other business for the board. So is there a motion to adjourn?
Before you do, Amy, did you have any business to share with the board about design review?
I'm thinking hard.
Somebody,
Oh, okay. Yep. Sorry. I'm like on bylaws. I thought you were talking about signs. Yeah, Diana Nicholas resigned from the design review, so we're gonna have to open up a rec for a new design review committee member.
Okay. I will, does Michelle know that?
Michelle Silly.
Yeah.
I think I
Yes.
did forward it to everybody on staff.
Okay, so we will have a vacancy and then I'll send a follow-up to Michelle. I think you actually sent this to me. So I'll go back to my emails and when I get back to my home computer, I'll reach out to Michelle and square that up.
Sounds good.
Okay, any other subcommittee updates?
I'll have something from CBC written up for next time.
Great.
Master plan meets on Thursday if anyone wants to watch.
Okay, motion to adjourn?
I make a motion to adjourn the meeting.
Second?
Second.
Okay, all in favor, Millie,
Aye.
Anthony,
Aye.
Michelle,
Aye.
Amy,
Aye.
and Carrie's an aye. Thanks very much. Have a great night, everyone.
You
Good night.
did night.
Aye.
Night.